Good morning. Welcome to Judiciary Full Committee. Members, go ahead if we can work on getting signed in here, clocked in. Madam Clerk, if you make the board available for members to punch in, thank you. Does anyone have any personal orders or announcements? I'll ask that as soon as we take roll here. I'll give members just another moment or two or three to get signed in. All right, Madam Clerk, you go ahead and take the roll. Thank you.
Mr. Chair, you have 14 members present. You have a quorum.
All right, good deal. Members, any personal orders or announcements before we get started? All right, sounds good. Just going to do just a rundown of kind of what's going to go on today, or hopefully. So first off, let me hit this. Item 2, House Bill 661. Chairman White has asked that be moved to the second calendar of 2026. Any objections? All right, seeing none. Second calendar of 26, House Bill 661. Members, we're going to start off with item 1, House Bill 809. Chairman Grills. Sir, you've got a motion and a second, and we can, looks like we have House Amendment 6945 adopted. We spent quite a bit of time on this bill last week, so the intent is to allow for another hour of questions and debate on this bill today. So I believe I've advised everyone, I've asked everyone to kind of have their questions ready, and we can move forward on that. Mr. Sponsor, you recognize, do you have anything you want to talk about before we go back out of session and pick up on our guests?
No, sir, Mr. Chairman. I'll just.
Okay, good. Chairman Doggett, you recognize.
Thank you, Mr. Chairman. What was the amendment code that we adopted last week, please?
I'm looking at 6945, House Amendment 6945.
All right. Thank you, sir.
Yeah, very good. 6945. 6945. And then we didn't adopt 44. So we adopted House Amendment 6945 last week. So. All right, very good. Members, we'll go out of session and hear from our guests. All right, without objection, we're out of session. And we had spent about 40 plus minutes on our first round of folks of 6 last week. So if we could, we had about 15 minutes in on our second round of folks. So I'm going to allow them to come back up and give them about 20 more minutes for us to offer questions. They've already given opening statements. So if I can get Mr. Hensley, Mr. Litz, I believe Mr. McDonald, Mr. Tharp, and Mr. Llewellyn, I believe we ended on there. So, gentlemen, appreciate you all being back. And you've already given your opening statements. I'm just going to ask the members if they have any questions for you all just to move from there. All right, members. First on the list, I have Representative Balso. And then Chairman
Thank you, Mr. Chairman. My question I'll direct to Mr. Llewellyn. As I understand it, you're something of an expert on FIFRA. Is that correct?
Yes, that is correct.
All right. And the EPA has promulgated regulations pursuant to the statute FIFRA. Is that right?
That is correct.
And, in looking at some of those regulations, in particular, Section 152.50, subsection F3, I noticed that an applicant is required to furnish with the application any factual information that the applicant has regarding unreasonable adverse effects of the pesticides on man or on environment. Is that accurate?
That is accurate.
And so the label that the EPA approves is in part a product of information that the registrant itself provides to the EPA, correct?
That is correct.
So that if a registrant were negligent in providing the factual information available to it about adverse health effects, that could result in an approval of a label that should not have been approved. Would you agree?
That is a possibility.
And if this bill that's before us were adopted, it would take away from any Tennessean the right to pursue a registrant in civil court for negligence for failing to provide factual information that should have been included on a label. Would that be accurate?
That's a question I can't answer because that gets into a legal area where my expertise is not. But to the point that you're making is that if a company fails to provide information or withholds information, that is a breach of the law and the regulations, and EPA and the Justice Department have the ability to go after civilly and criminally the company.
Well, I'm looking at the amendment that we adopted at our last session, 6945, and I can tell you that the only carve-out in this statute deals with information that is knowingly withheld, concealed, or misrepresented. And you would understand, Mr. Llewellyn, that negligence is different from intent under the law. Are you aware of that?
I am not a lawyer, so I can't go on that place. But
Okay.
in terms of the aspect of FIFRA and the requirements, there is no difference in terms of the requirements of FIFRA than any other regulated product. So the regulation of products in the U.S., give an example, pharmaceuticals, it's the same demands. So it is the registrant, the applicant who provides the data to the regulatory authority to evaluate. The regulatory authority also has the ability to go on its own and look for information that the registrant has not provided. So that is something that EPA does as well, as they look at the totality of the evidence beyond what is provided. So it's a difficult lift for somebody to try to hide anything because all records are open. So if a company conducted a study, that record, there's a record of that study being conducted. EPA does have access to that study being conducted, whether or not the registrant reports it. So if there's something's been done, EPA can go find it, and they have the ability to do that.
And you understand, Mr. Llewellyn, from the statute itself, from FIFRA itself, Section 6A2, that the obligation that a registrant has to provide factual information regarding adverse and unreasonable health effects is an ongoing obligation, correct?
That's right. That's, as we talked last time, it's a living registration, and the requirement is there for the registrant to provide anything that they are aware of in terms of their studies, and also the EPA is aware of what's going on in the general scientific literature as well. So it's a dual mandate. So EPA is doing that, and the registrant has to do that. So EPA is making sure that the registrant is not hiding anything.
So even in a case where a registrant may have accurately provided to the EPA all adverse information regarding unreasonable health effects, if the registrant fails negligently to provide additional information during the course of the registration, that could result in a label that is inaccurate and misbranded. Would you agree?
I would say that it goes both ways. It could possibly go that way. It more likely would go the other way, where the label would not get through because of the very strict and comprehensive evaluation by EPA. So if there are questions that are not addressed or not answered to satisfaction, EPA will continue to dig. They will continue to hold that registration up. So while it's possible, it's not probable.
Do you have an understanding that part of what the proponents of this bill are asking this committee to do is to take away rights that Tennesseans currently have to file a civil action in negligence and product liability against registrants who misbrand a label in a failure to warn case?
So from the legal aspects, that's outside my field, but you bring up the fact of misbranding. So in this case, a company who is following the law by EPA and has a label registered by EPA, if the company does something other than what EPA has allowed, then that product is misbranded and is illegal. So there is no aspect for that company to legally market that product. From the rights perspective, I would pass it on to the lawyers in the room, but my understanding of the law in terms of what we're discussing here today, in terms of FIFRA, is that it just maintains the current situation. There's nothing new. There's nothing that's been removed. It just clarifies what the responsibilities are and who has responsibility for what.
Well, when we were here last, Mr. Tharp, my good friend and colleague in the legal profession, very articulately set out that there are actually three types of product liability claims that can be brought under a statute: a failure to warn, a design defect, and a manufacturing defect. Do you recall that?
I do recall hearing that.
And the problem I have with this legislation, Mr. Llewellyn, is that it seeks to take away one of those rights. It seeks to take away the failure to warn claim. And you probably understand that in our own Tennessee state constitution, all of us take an oath not to vote for bills that are injurious to the people or that take rights away from them that are protected by the Constitution. And one of the rights that Tennesseans are protected by is Article 1, Section 6, which gives Tennesseans the right to a jury trial if there's a dispute in a civil court, for example, in a negligence action. And so one of my final questions to you would be, how is it that we, as legislators, can take away a right of a citizen to bring a products liability claim for negligence consistent with our oath not to take away rights from Tennesseans under Article 1, Section 6 of the state constitution?
So from a purely regulatory FIFA perspective, there's nothing being taken away by this bill. The other aspects, as I said, there's nothing new. The situation is the same as it was yesterday, and it will be tomorrow. So from that perspective, I can't opine on the legal aspects.
Well, and let me ask, if I could ask you this one final question. You know, we know that our U.S. federal courts of appeals have split on the issue of whether FIFA preempts state law products liability claims. The Ninth Circuit has said no. The Third Circuit recently has said yes. And as I understand it, some registrants have filed a petition with the U.S. Supreme Court to resolve that split. And if, for example, the U.S. Supreme Court were to side with the Third Circuit and rule that FIFA preempts all of these state law claims, then that would effectively moot what we're doing here. So the question would be, should we wait until the Supreme Court has a chance to rule on the registrant's petition before we actually hear the merits of this bill substantively?
I would disagree in the fact that the current bill as it is does nothing to change the current situation. So it has no bearing on what happens in the future from the courts. It just preserves the status quo as it is today.
Thank you, Mr. Llewellyn. Thank you, Mr. Chairman.
Thank you, Representative Bowles. So next on the list, I have Chairman Todd.
Thank you, Mr. Chairman. And I guess I want to start out by asking, I think Mr. Tharp, the attorney, a few questions. In this draft, in this amendment that we've adopted that makes the bill, is the word immunity in there at all?
Y'all can have an exchange there. You don't need to be recognized.
Mr.
Just be
Chairman.
polite. Don't talk over one another. Thank you.
Thank you.
Yes, sir. Thank you. No, sir, I did not see that word.
Okay, I couldn't find it either. Does this, if we pass it as is, would this prevent any lawsuits for negligence?
No, sir.
Would it prevent any lawsuits from a chemical doing harm to someone?
No, sir.
Would it prevent anyone from suing over design defects?
No, sir.
Would it prevent anyone from suing over manufacturing defects?
No, sir.
Does this bill just take away the right to sue for mislabeling or failing to warn completely, or only the failure to warn when a regulatory agency prevents a company from putting it on the label?
Can you rephrase that question, sir? I'm sorry.
Does it take away the ability for somebody to sue for failing to warn altogether, or only in a situation, as is mentioned in here, I believe in the wording of this, when that company was prevented by an agency from putting it on the label?
Yes, sir, I understand now. It would be the latter, the second part of what you said.
Well, that's what I've been understanding, and we've gotten tons of emails about this, and you'll probably hear folks talk on the committee shortly about how many emails they've gotten from the public saying, don't give these companies this immunity and all these other things that's been talked about, which is not what we're doing. And also how broad it is. It's just letting companies get off with poisoning people. That's not what this is about. This is literally about labeling when they're prevented from labeling by the federal government in this situation. Is that correct?
Yes, sir.
Okay. Thank you for that. Thank you, Mr. Chairman.
Thank you, Chairman Todd. Next, let's have Chairman Eldridge, sir. You're recognized.
Thank you, Mr. Chairman. My question is going to go to the farmers sitting down there. John Litz, how do you see this impacting your day-to-day operations if you don't have the availability of pesticides to use? Do you see what do you see changing for you?
Well, I see the way that we have to operate on a daily basis as far as row cropping will change completely because we won't have the availability of a chemical to be able to control weeds in a conservation manner. In a conservation manner, I mean that a lot of our farming, 90% of our farming operation is all conservation planning. We go in and we'll spray the ground. We never work the ground up, and because a lot of the ground that we farm on is ground that is marginal because of slope, and that prevents that erosion of that topsoil off, and it also movement of chemical through water transformation with soil leaving. And also, if that soil if it's ever gone, you never ever get it back. And as I said in my statement before, when I was in high school in 1979, the farmer fed himself and 54 other people, and today he's feeding approximately 160, and that's simply because of conventional tilling is just a thing of the past. What we would have to do is we would have to work our ground up, plant our crops in loose, worked ground, and then we'd have to go back with cultivators and be able to cultivate this and try to remove as many weeds as we possibly can, because any weeds that are out there take away from our production. And I mean, it's I could imagine that my row cropping operation would drop to probably 25% of what I'm doing now, and so it's it just would be devastating for us. And we're struggling now trying to make it with the number of acres that we're farming to be able to make a profit, and because our margins are so low in this, and as I said before, this product is a safe product, and it has it's been on the market now for pushing 50 years. And if it were so bad and it were so dangerous because we as farmers handle a higher rate of actual chemical than is what you would get in a spray bottle through a hardware store or Walmart or lumber, or any kind of supply store that you use in your garden operations, our concentration is very high. We also mix that concentration in with water to dilute it down enough to be able to get it to where it's at a safe rate. But it would put us as agriculturalists back approximately 50 years in our production. Now we would.
Thank you, Mr. Litz. Does that answer your question? I'm trying to be just concise with our time. So I think he answered your question. Do you have another one?
It leads to my next question.
Okay.
You've used these products for years on your farming operation, I know.
Yes.
And I would take it that you have feed your family from your farming operation.
Oh, yeah.
And you feel comfortable doing that, given the chemicals that you use.
Yeah, no doubt. I mean, if these were so dangerous, then it looks to me like that there would be dead farmers laying everywhere with the concentration that we were using of it with Roundup jugs right beside of them. So I mean, it's just not. It's labeled correctly. The instructions about application are on the label. All the information is there that needs to be there on the label right now.
Thank you, Mr. Litz, and thank you, Chairman.
Thank you, Chairman Eldridge. Next, let's have Representative Johnson, ma'am. You're recognized.
Thank you, Mr. Chair. I guess for Farm Bureau or really anybody for this bill, your claim is that if this bill is not passed, it will have a mass impact on agriculture in our state. And I guess I'm curious why that's not happened in the many other states that have voted this bill down. We've got Nebraska, Missouri, Mississippi, Iowa, and more that voted this bill down, and it hasn't had an impact on farming in those states. So your claim that it's going to have this massive impact, what is that based on?
Thank you, Chairman. Happy to take that question. So from our perspective, there's a couple things there. The type of litigation that we've been discussing only really started in 2016. This level of that a company was sued because they failed to warn for something that the federal government says that they can't warn for has only been successful within the past 10 years. And so, you go through a period of appeals processes, and you go through, we all lived through COVID and the kind of pause that kind of took place then. This has only been tried in a couple of in states for the past couple of years. Georgia has passed this legislation. In fact, the amendment you're looking at is based upon what Georgia just passed. And we're looking at a big, broad perspective here. The reality is that if this type of litigation continues to be successful, when based on the fact that the lawsuits are based on a failure to warn for something the federal government says they can't warn about, I mean, you're all successful people. You understand the business mindedness of companies. If they're in a position that they know they're walking into a court case because their hands are tied behind their back, at some point they're going to stop providing those products to our farmers, and that's our major concern. And so, yes, we are early in the process of trying to get different states to try to pass this legislation. We're early in that process, and we just happen to be, this is the second year to my knowledge that this type of legislation has been tried, and it's passed in Georgia, as I said, and we think it should pass in Tennessee. And I think from our perspective, the reason we're so passionate about it in Tennessee, and Mr. Litz and Mr. McDonald have explained this very well, we're leaders in no-till agriculture. So about 20% of the row crops across the country are produced using no-till production practices. In Tennessee, all of our major commodities of corn, soybeans, wheat, cotton are over 80% no-till. And so our farmers inherently rely on these products because of the way that we farm, and that there's multiple reasons that we do that, and mostly it's to stop runoff, and so it's good for the environment, and that's why they do it. It's good for their farms. And so if we were to lose access to these products, our farmers would feel the impact of that because of the way that we farm in Tennessee, that the net benefit for the environment.
I guess, as I said, it's just not demonstrated to do that in other states, and it's been a number of states that have turned it down. You could name one state that's passed it, but it's been a number of states that have turned it down. And I have to go back to, it's unfortunate but these court cases are being won by the people who bring them because it's proven that these chemicals are harmful. And so we cannot remove the ability to seek action and give billion-dollar companies the ability to harm whoever they like. And the reality is, I believe that Tennessee should join the states that have voted it down.
Mr. Llewellyn?
Yeah, thank you. Just picking up on that. So as we discussed last week, it takes about 10 to 12 years for a new chemical or new pesticide to come to market. Any activity today is something that's going to be felt in the future more so than in the current or the very near future. So that's another aspect. The other piece is eroding the trust of the consumer and the populace in terms of our ability to protect them is important in terms of what products they're exposed to. So from a safety perspective, there is the most rigorous exercise is through EPA for pesticides. So it is a very, very rigorous evaluation. As I said last time, there is no chemical, there is no substance on earth that is not without poison. The dose makes the poison, and also the aspect of intended use. So if the intended use has been evaluated and approved and the exposure does not happen to cause whatever toxicity might be associated with a compound, then that toxicity never occurs. So the aspect that all chemicals are dangerous is true. The other aspect is that the intended use of a chemical, in this case a pesticide, is evaluated by EPA, be that an agricultural chemical use, be that a homeowner's use. So each of those uses is evaluated for the safety of the people who are involved in application, the people that are downstream from that application, or the public in general, and also the environment. So not only the intended use, what you're trying to kill, but also any detrimental impacts on the other aspects of the environment, other organisms not intended, non-target, like insects, beneficial insects, and or people who may be exposed from that use. So the aspect of safety is very well defined before a product ever makes it to the market. And then it is a living registration. Any information that comes up is reevaluated. So in the case that we've heard that one chemical in particular is being the subject of lawsuits, there is no country in this world who has ruled against removing or has ruled to remove that chemical from its registration. And we've heard states do that as well. So the state of California tried. In fact, the chemical we're talking about is still registered for use in California. California has the ability, if they feel that it's unsafe, to remove that registration at any time.
Doesn't this bill allow all pesticide manufacturers, including foreign companies like U.S. adversaries like China, to sell harmful chemicals to U.S. farms and families and not disclose the harm that is known to be a risk?
This bill retains the status quo and clarifies the status quo. It does not allow anybody to sell a product that would be a danger to the user or the intended use. And as any product that is sold in the U.S. right now, the manufacturing aspect is almost agnostic in terms of the safety. So the safety has to be the same. The same bars must be hit. So if a foreign company wants to bring a pesticide to market, they have to provide the same information to the EPA, and the EPA will evaluate it in the same way as to any company that's brought it forth.
If I may go along, when he's saying that the status quo doesn't change, what he's talking about is the registration process. So the thorough process that the EPA undertakes is not what we're discussing here. What we're discussing is in our court system, should a company that is told by the EPA, you're not allowed to put that warning label on that product, be liable for not putting a warning label on that product? And from our perspective, when you've said that concerns about health and safety of our farmers, that when this idea of talking about this legislation was brought about, that was our concern as well. And I think, as we've heard today from Mr. Llewellyn, if somebody is harmed by this product, there are other avenues in Tennessee's court system to bring those cases. And that was an integral part of Farm Bureau's support in this legislation, was that if there are legitimate claims that should be brought about, there is an avenue to do so. This is looking at the amendment, it really is just a defense of the federal government has said you're not allowed to do, this is what your label is. You can't change it. You can't, in fact, if you do change it, you are breaking federal law. And you are allowed to defend yourself in Tennessee courts in the situation that somebody claims you should have warned them about that.
And I appreciate your perspective, as you continue to say, from our view. Well, from my view, we're removing an avenue, and probably the most important one.
Thank you, Representative Johnson. I have Representative Hardaway next.
Thank you, Chairman, and good morning to you, gentlemen. And a lot of my questions were answered in your responses to Representative Johnson and Representative Balso. But I am curious. I'm still not clear on whether there are, and anyone can take this, whether there are potential lawsuits for civil action, or whether there's some way to get to a criminal charge on this. anyone can take that if we don't pass or if we do pass this legislation.
Mr. Tharp.
Yes, sir. So this bill does not address in any way any criminal action. This is only related to civil action. And so underneath the civil umbrella, you have various different claims, as we discussed last time, that a plaintiff could bring if they're injured by a product. And typically, under Tennessee law, if you're injured by a product, you're going to bring a claim under the Tennessee Product Liability Act. And so you've got design defect, a manufacturing defect, or a failure to warn claim. And this bill only addresses failure to warn claims. So nothing to do with criminal, only under civil. And as you're under the civil umbrella, just one little piece of the potential pie of claims, if you will, that you could bring as a civil action against a pesticide manufacturer.
President Hardaway, do you have any redirect?
I think this gentleman wanted.
Yeah, thank you very much.
Mr. Llewellyn, you're recognized.
Thank you. And I'll go on to go through the aspect from a FIFRA perspective, is that there's nothing that changes for the ability from the federal government and the EPA to seek civil and criminal penalties against a registrant who knowingly or unknowingly breaks the law. So nothing has changed there from a legal perspective for the federal side.
All right, I'm not a lawyer. It's a good time for me to brag. My son is. He's a brilliant lawyer. But if I have to err, I'm going to err on the side of caution in two ways. One is to fulfill my oath, and the other is my obligation to protect public safety, which is our number one charge as elected officials. So with my limited knowledge and information, I'm going to ask you whether EPA has ever been wrong where it has caused harm to the public.
Mr. Llewellyn.
Thank you. So the aspect is that science is never static, and we learn more and more every day. So what we understand is safe 50 years ago may not be safe today, as we've learned. And that aspect is captured within the world of pesticides through EPA, through mandated every 15 years there's a re-review, but also, as we talked about, it's a living registration where at any time any new evidence comes to light, that evidence is and does get evaluated by EPA. And then there are registrations that get revoked based on new evidence. So this happens all the time. So every year there are revocations of pesticides or uses of pesticides, because again, it's not the chemical that's regulated, it's the use of the chemical. So a chemical can be okay for use on an agricultural basis, but the risks are deemed to be too high for a consumer. EPA will remove the registration for consumer products, but will preserve the agricultural use. So it is an ongoing process. It never stops. As long as that registration is active, it is duty bound by the registrant and EPA to ensure that it is safe. So that is the goal of the community, is to make sure that the use and the protections that are in place are safe and protecting the users and anybody who follow on exposure after that.
All right, thank you.
And thank you, Representative Hardaway. That concludes our time for this panel, and we appreciate you all being here. I'm going to go ahead and move forward. Without objection, members, should we move to the next panel? All right, without objection. In an effort to be fair, what I'd like to do, members, if we could, is bring up, I've got a list of folks that were here last week, because we have folks that signed up last week and this week, and out of fairness, I think we should hear from them if they've been here 2 weeks in a row. So I have Mr. David Schwartz, Jessica Hinton, and Matthew Hinton. Okay. So David Schwartz, are you here? Is David Schwartz here? Okay. David Schwartz is not here. Okay. Scratch. Jessica Hinton. Is Jessica Hinton here? Okay. Scratch. Matthew Hinton. No, that's not how it works. I'm going to call out names if you're here. Just let me know. Matthew Hinton, are you present? Sir, have a seat. Jessica Curley, ma'am, are you present? Please come up here and have a seat. Brittany Ruiz, ma'am, are you here? Okay, come up here and have a seat. Jamie Wall. Jamie, are you here? Scratch. Courtney Parker, ma'am, are you here? Please come up here and have a seat. And Tiffany York. Is Tiffany York here? Okay. Tiffany York. Okay, thank you, ma'am. You and both children are more than welcome to come up here and have a seat. All right. Members, these are the folks that I had on the list last week, and I was going to give them, you are going to have, just because this bill has been double referred to two committees, over to this one. It's been on calendars for weeks. I know about every member I know I have has been talked to by several people. So I'm going to limit you all, members, we're going to limit them without objection to 1 minute apiece. 1 minute apiece. All right, sir, if you go ahead and introduce yourself, we'll work our way down from my right-hand side down to the left.
Hey, sir.
Yes, sir.
My name is Matthew Hinton. My speech is timed for 2 minutes because we had 2 minutes last week, so this is going to be really hard for me to complete this in a minute. Can you just give me 2 minutes, please? Yeah, I was here last week. I drove 2 hours last week.
All right. Member, you want to, members, what do y'all want to do? Do I have a motion for 2 minutes, or do I have a motion for one? What do you want to do? One or two? Two? All right. Without objection, 2 minutes. All right. Sir, you recognize 2 minutes.
All right. Thank you, sir. My name is Matthew Hinton. I served this country honorably for 10 years in the military, protecting the freedoms and values that make America great. Today, I stand before you as a veteran, as a husband, as a father, and as a Tennessean, deeply concerned for the health of our families. Just 2 months after I married my wife, I was diagnosed with testicular cancer. It was a life-altering moment as we searched for answers. We were confronted with research linking exposure to chemicals like glyphosate, which has led to over $10 billion in lawsuit settlements from Bayer. If these companies' products pose no risk, why are they paying out billions of dollars in settlements? The truth is, these lawsuits are built on undeniable harm caused to real people, and yet the companies continue to claim these chemicals are safe based on their own internal studies. Independent research tells a different story, one that includes higher cancer rates among farmers, increased kidney disease, and a growing list of reproductive complications in women who are exposed to these chemicals. This is personal, it's not political. Women across Tennessee are struggling with fertility issues, hormone disruption, and pregnancy loss. What role are these chemicals playing in that? Children playing in treated yards, women unknowingly exposed during pregnancy. This isn't just about farms. This affects homes, schools, and neighborhoods across our state. House Bill 809 strips away the ability for people to seek justice when they are harmed. It grants legal protection to billion-dollar corporations that profit from chemicals. As a lifelong Republican, I believe in personal responsibility when harm is done. There should be accountability. I serve to protect the country from outside threats. But today I'm asking you to protect us from a silent one happening right here at home. Please vote no on HB 809. Do it for women, do it for the children and the future of this great state.
Thank you, sir. Appreciate that, ma'am.
I'm going to keep things short and sweet this morning, as the items I would have spoken on were discussed in our last meeting.
And what's your name?
My name is Jessica Hurley,
Okay, thank you.
and I am a Republican and a concerned Tennessee citizen. I oppose this bill because it has taken away constitutional trial rights from Tennesseans. I strongly encourage and request that you vote no on this bill. Thank you for providing us the extra time and the opportunity to speak today.
And thank you. Ma'am, you recognize.
Hi, my name is Brittany Ruiz, and I am very opposed to HB 809. As a third-generation Republican, my family has long-standing commitment to our nation. My grandfather served as a United States Army Air Force pilot. My father served in the Navy, and my brother completed 2 four-year terms in Afghanistan and Iraq. I am deeply patriotic and concerned about China's strategic approach to acquiring our farmland and securing immunity for all of their imported chemical products. For context, please consider these following statistics. HB 809 would significantly benefit China if passed. The largest pesticide corporation is headquartered in China. Syngenta, acquired by ChemChina in 2023, is now the largest pesticide producer and exporter with annual sales exceeding $28.8 billion. The Environmental Protection Agency has registered over 200 of their pesticides for use in the United States. Since 1982, Bayer has had deep ties and numerous businesses formed and headquartered in China. Bayer Crop Science of China makes an estimated $11.5 billion. Bayer's headquarters remains in Germany, with a criminal history of drugging and experiment on Jewish prisoners during World War II. Bayer has registered over 400 pesticides with the EPA. In 2023, China entered an agreement with Bayer Monsanto granting China specific accommodations to facilitate the merger with Monsanto. BASF, a German corporation, reported annual pesticide sales of $10.8 billion in 2024 and has registered dozens of pesticides with the EPA. The EPA has only ever removed 5 pesticides. Notably, 70% of all pesticides are now manufactured in China, with over 553 Chinese corporations involved in the pesticide industry, surpassing any other country in this sector. HB 809 would provide substantial legal immunity to foreign companies, particularly those from China and Germany. Given these facts, it is imperative that we recognize HB 809 as a potential national security threat for our country. It is unacceptable to grant immunity to the primary adversary of our nation. I cannot find an attorney experienced in product lawsuits who feels confident in if HB 809 passes that there will be justice for families, children who have been harmed by these pesticides, more specifically China's pesticides. I urge you to exercise your responsibility as members of the Judiciary Committee and vote against HB 809. Your constituents deserve your utmost attention and consideration. Thank you so much.
And thank you, ma'am. All right. And to you.
Hello, my name is Courtney Parker. This is Jet. I found a very interesting article when I was deep diving into this, because once I saw this legislation up, I couldn't believe what I was seeing. And I found an article based on a study that was done in October of last year, so 6 months ago, and it talks about how the new Roundup is 45 times more toxic to human health. So I don't know if you know, they took a lot of the glyphosate off the market, put a new product on, and it has 4 new chemicals in it. And when you take those into account, they're much more harmful than glyphosate is, and they're selling that in the stores. And I actually went to Target and looked, and there they were, the 4 chemicals listed, and in the article it talks about why they're more toxic. And there's one called diaquat dibromide, which is 200 times more toxic chronically, like long-term exposure. So, you know, dad and grandpa and mom and who's ever gardening and spraying this on their lawns, and now, it's being sold now, are in 10, 20 years going to be getting health problems. And it's not just any health problems. It talks about reproductive concerns and long-term health problems and birth development abnormalities, reproductive dysfunction, kidney failure, all sorts of bad things, you know, and this is one of those things we're talking about the label. There's no extra warning. I went and looked. It says it's an eye irritant. It does not say it can cause anything else. So this is the kind of thing we need to be worried about going forward and looking at, you know, other new products that can be put on the market. This one's supposed to be safer. Glyphosate's out of it. It's way worse. Thank you.
And thank you for that. All right. Ma'am?
Hello, my name's Tiffany York. This is Ivy. Mine's a bit more personal. I have an 8-year-old daughter at home, or she's at school, and her best friend 2 years ago, so when they were both 6, was diagnosed with non-Hodgkin's lymphoma. 6 years old, guys. And he's been in treatment for that for the last 18 months or 2 years, whatever it's been. It's been devastating to watch, and the toxicologist could speak more on this. I'm no expert. I'm a mom of 3 kids. So I don't know that I can give her my time, or she already spoke last week. Would that?
No, this is time for you.
Okay.
So thank you.
All right, so then just to wrap up, there are hundreds of chemicals that have been banned in other countries that are used in the United States that have been approved by the EPA. I'm going to do my best to pronounce 10 of them. we'll see. 4-8 is one, paraquat, atrazine, turbofos, aldicarb, chlorhexidine, ethopropos, menthamol, propanol, and acephate. Those are all used in the United States but banned in other countries, though they are approved by the EPA. That's all. Thank you.
And thank you. Members, any questions for, I guess I do have a list. I have Representative Powell. Sir, you're on the list first. All right. And then I have Representative Russell second.
Thank you. I'm glad I finally get to ask questions of a panel. My question is, has all of you seem like you're here on a personal nature. Has anybody paid you to be here or testify? Okay. We've heard that farmers are asking for this. I guess this gentleman sitting in the first, that spoke first. are you hearing from fellow farmers or others in the community that are looking for this bill to pass?
No, not necessarily, no. I'm sure farmers, big farmers are looking for it to pass. They're fearful that, if they can't get glyphosate, they can't, make money, they can't grow food, and I totally understand that on a personal level. But at the same time, I feel like you can't spray these chemicals in good, with knowing what they're actually capable of. I feel like that's wrong.
Anybody else?
What was your question again?
Sure. Are you hearing other farmers asking for this? I mean, we keep hearing testimony that farmers are asking for this, but.
I will say from my personal experience, I have been around and surrounded and support local farmers, and not a single person in our farming community, in our CSAs, in the farmers markets have been proposing or even recommending this bill. And I will say that one of my posts went viral on X, and I will say that I would say 100 to 1 against this legislation with Tennessee's specifically. So I would just say that this is not something that Tennessees want.
And one last question here. So we've heard a lot about the EPA. I know currently a lot of government is being gutted, organizations, and government agencies like the EPA. And I guess I'm curious. It seems like already some of these practices are failing us currently. Clearly for you and your family. So, given the fact that the EPA and some of these different checks that we should have in place are failing, do you, and then we take away the rights of litigation, what do you think is going to protect us?
Nothing. There's going to be no protection. That's the thing. This is the best protection because it gives them a reason not to be stand up, Like, the products are already pesticides. They're already chemicals. The side means to kill. All they do is kill things. Every pesticide is intended to kill, and it harms humans. And so the whole purpose of having legislation like this is to protect people against companies whose job is to create things that kill, we do have benefit, but there is no doubtably, no question, a harm to humans. And we need to protect ourselves. We need to protect our children by keeping a law in place that helps protect us. It protects us preemptively, and then it protects us when we're harmed. And there is no doubt that people are harmed. I mean, going through this legislation and looking at things, my grandfather was a farmer. He died of cancer. He used Roundup. Did we sue? No, no idea. My mother was an avid gardener. She had breast cancer. She ended up passing away, but before she passed away, we checked her toxicology, and the #1 toxin in her body was a yard chemical, a yard pesticide. These things harm us and we don't necessarily know, but this is the best way to do it, is keeping this rights in place.
Thank you. Chairman Russell, you're next.
Thank you, Mr. Chairman. It was brought up on the panel the number of products this would affect. Could our legal define how many products this will affect?
Any objection here from legal? All right, Ms. Fogarty, you're recognized. We're already out of session.
Michelle Fogarty, Office of Legal Services. The bill as amended applies to a pesticide registered with the Commissioner of the Tennessee Department of Agriculture in accordance with our state law and with the EPA under FIFRA. If you go to the Department of Agriculture's website and look at registered products, there are over 15,000. I haven't reviewed all of them to see which ones of those are registered with the EPA under FIFRA.
Thank you. So just to be clear, Tennesseans won't be able to enter into a lawsuit for over 15,000 products.
Ms. Fogarty.
Statutory interpretation is for the courts. As written, it says that the amendment says that a pesticide that is registered with the Commissioner and with the EPA under FIFRA is deemed a sufficient warning label for the purposes of a civil action commenced concerning the duty to warn or label.
Thank you. That answers my question.
Thank you, Chairman Russell. Next, let's have Representative Johnson. You're recognized.
Thank you, Mr. Chair. You spoke about your older child's friend. I believe we heard last week from the toxicologist that non-Hodgkin's lymphoma was directly related to this product. And I think we heard that it changes DNA, which causes a lot of different cancers. So you feel pretty certain that that's the link, that the reason that this friend of yours.
I mean, yeah, I don't live in their house, but
Yeah.
knowing what I do know about all the lawsuits and the link and what was that? Yeah, and he's also a soccer player. I know they spray those fields to keep them pretty. You know, he is an avid soccer player. So yeah, that's my best guess. But again, I'm not the toxicologist, but knowing what I do know, yes, I believe so.
And I feel like that's what the testimony that we heard last week from the expert. And now that they have done the studies and they know what it can cause and they know the links, then they know the links to infertility and all of those other things.
Right.
But thank you all so much for being here.
And thank you. I have next to Representative Hardaway. Sir, you're recognized.
Thank you, Chairman. The longer this goes, the scarier it gets. You just mentioned spring soccer fields, and my son went to college on soccer and then walked on to play football and then decided he wanted to play rugby. What you just shared with me makes me start thinking even more critically about this. My father passed from cancer. My brother passed from cancer. So you really got me thinking on this. If you're looking, and this can go to anyone, if you're looking at the bill and you're looking at the law and you're thinking to yourself, will the farmers be protected? Will the farmers be protected if the chemical companies are the real culprits here? I'm trying to figure out whether we keep saying we're going to cause inconvenience to the farmers and possibly they'll have to change their business model. But is there any real liability for the farmers here from your research, or is the liability that we're talking about the chemical companies and their failure to warn?
Yeah, I can speak on that. So when I was doing some research, I read PubMed articles about how this affects farmers and farm communities. And it's actually surprising. Like, you're dealing with people, you know, they say, you know, they're equipped to spray this on the crops, so therefore, you know, and they should be dying like flies. The truth of the matter is a lot of this stuff is sprayed by big machines. There aren't a lot of people around. The ones that are in the fields are migrant workers and seasonal workers. They're the ones getting sick. They are not the ones filing lawsuits because they're getting ill. A farmer is also, per the study, there's 54,000 people in a study that talked about non-Hodgkin's lymphoma, and 41% of them, they're all farmers, 41%, or they're 41% more likely to get that cancer. So there is an increase in cancer with that. And then those communities, rural communities, all that stuff gets sprayed, goes into the groundwater, goes into the beef, the fish, everything around there, and then you eat it as well. So does this, I would say this harms farmers more than anybody. And the rural communities more than anybody. And then also with that is children, people playing in soccer fields. The kids, you know, kids eat more food for their body mass. They have more skin on them, so they absorb more chemicals. They're rolling around in grass. They're doing all sorts of things that cause them to have more pesticides on their body, whether it's pesticides that are sprayed in this room, pesticides that we spray in our homes or outside our homes or on lawns. Like, pesticides are everywhere. And herbicides and all these different things. Pool chemicals count in this bill. You know, there's a whole bunch of stuff that counts. But to your point, farmers are definitely a high-risk population.
Just one more, Mr. Chairman, and that's it's probably more of a statement. Anytime you mention China these days, I think about Hurricane Katrina and the fact that we tried to help them by putting them into temporary housing that had products from China, and found out we were killing them with the chemicals coming from the materials that were made in China. So anytime you tell me that China has a heavy hand in delivering products to Americans, then I'm starting to decide that I need to do, as I said earlier, err on the side of caution. And I want to thank the veteran for his service and for being here today. My daughter is a veteran, my dad was a veteran, my brother, all my uncles, et cetera. So I admire what you've done, and I also admire your service today in bringing your experience to us so that we can make a decision that's in the best interest of our constituents. Thank you, Mr. Chairman, and thank you all. I didn't get a chance to hear from, was it Jets? So, Mr. Chairman, if he comes back next year, I want to hear from him.
Not a problem. Next on the list, I have Representative Bolsa. Sir.
Thank you, Mr. Chairman. I have 2 questions for legal, if that's permissible.
That is permissible. Yes, sir.
Great.
Ms. Fogarty.
Thank you. Ms. Fogarty, in response to Chairman Russell's question, you referred to the language of the amendment that the label will be deemed a sufficient warning. My understanding is that our current Products Liability Act creates a rebuttable presumption if the manufacturer uses an approved label. That is, that a manufacturer is presumed to have given an adequate warning if it complies with the label, but that presumption could be rebutted by evidence. If this bill were to pass, does this language that the approval of the label provides sufficient evidence change that rebuttable presumption to a conclusive presumption?
Michelle Fogarty, Office of Legal Services. Ultimately, I think that's a question to be determined by the courts. As written, the amendment does say notwithstanding another law to the contrary. The provision starts with that, so that means that the language that follows that takes precedence over any other law that is contrary to that. And it does state that the label is deemed a sufficient warning label for the purposes of a civil action.
And my second question, Mr. Chairman, also to Ms. Fogarty, is this. There's been discussion here about whether this bill takes away a claim for negligence. My understanding of our current Products Liability Act is that it makes a defendant liable if a product leaves a defendant's possession in a condition that is, quote, unreasonably dangerous, close quote. A product is unreasonably dangerous if the manufacturer knows or should know of an unreasonably dangerous condition but fails to warn against it. So would you agree that if this bill were to pass, it would actually remove from any citizen the right to bring an action against a manufacturer on the basis that the manufacturer should have known of an unreasonably dangerous condition but failed to disclose that in the label?
Again, I think that is a determination that's going to have to be made by the courts.
Is that all, Representative Bolsa? Okay, thank you. Next on the list, I have Leader Lambert, sir.
Move to return into session, please.
All right, proper motion that's seconded. Any objection? All right, seeing none. Thank you all for being here today. Members, we're now back in session. We're on the bill as amended. Questions for Chairman Grills. I have Representative Russell. Sir, you recognize.
Thank you, Mr. Chairman. And just to be clear, the legislative intent's not to interfere with any ongoing litigation.
Chairman Grills.
Thank you, Mr. Chairman, and that is correct. I believe the start date has, this act takes effect July 1st, 2025, the public welfare requiring it, and applies to causes of action occurring on or after that date.
Chairman Russell.
And are you aware that it affects over 15,000 products?
I'm aware.
Chairman Grills.
Thank you. I'm aware that it affects all the products that FIFRA has had to go through their process, and the Tennessee Department of Agriculture has approved for the farmers' use.
Chairman Russell.
And are you comfortable with that?
Chairman Grills.
Thank you. Yes, I am. I believe that we have and here's the deal, Chairman Russell. I don't believe that anybody is required to use any of these products. We're not saying you have to use these products, but we're saying that there's a fiduciary duty by the EPA to make sure that these products are safe and that the label that is put on these products is a accurate label. And because they're held to that responsibility, they're held to that accountability, they have to do that. And the owner or the company that may have the product, they're caught between a rock and a hard place. Either sell the product as labeled by the EPA, or add a label or add a warning or whatever you would want to see on there, and be off a label. So they're breaking federal law. So what do they do? And what would you do in that situation if you were that company?
Members, y'all can have an exchange without being recognized.
Thank you, Mr. Chairman. I just want to say I appreciate everything you do to support our farmers. I'm just not here for the bill yet. I just have a concern down the road where farmers may get cancer, their children may get cancer. But I do appreciate you standing up for our farmers and what you do as a farmer. So thank you.
Well, thank you. And I want to say, too, that I had several farmers from back home. Agriculture is number one industry in the 3 counties I represent. The gross receipts from the state of Tennessee, 10% of the gross receipts of the agriculture community come from my district. So we are farmers. But the farmers are so busy right now pulling pivot heads off, moving people out of the houses that the water's coming up in, and getting ready to put in a crop this year. So that's the reason several of the farmers that wanted to be here couldn't be here. And they asked me to make sure that to let the committee know that there's some different people that wanted to be here to speak, but they just could not be here today.
Representative Powell.
I guess to the sponsor, I mean, clearly you know that we have no jurisdiction or can't do anything with the EPA. I mean, that's a federal agency. I mean, so the fact that we're trying to dictate to the EPA, certainly you know that, right?
Yes, sir. I totally understand that, and we're not trying to dictate anything to the EPA. We're just trying to say that the EPA has a job to do, and if they do their job correctly, then the person that has this product should not be held to a standard or be held to court, unending litigation because they won't put something on there that some lawyer wants them to put on there. Go ahead. I'm sorry.
I guess to me, I see a lot of parallels here, and it almost seems like we're revisiting the entire smoking debate here. And I feel like I'm living through the movie Thank You for Smoking. I guess the difference is it's thank you for killing weeds because they're killing us. I mean, the difference is smoking is a personal choice, and we relied on the government for years on inaccurate information, whereas this, if this is introduced to the community, and I understand the role that some farmers believe this plays, but my concern here is that this is something that impacts people who unknowingly are not trying to be subjected to these different chemicals, but they have no choice because it gets in our food. It hits farms that don't use this product, that are neighboring farms, and it's toxic, it's poisonous, and I think that the only protections we have, just like in smoking, were litigation. And so when we're limiting what we can do from a litigation standpoint and taking away the rights of farmers and Tennesseans to pursue that, we're setting a dangerous precedent, and we're giving unbelievable control to a foreign company. And that's what this is. I mean, this group is not based in the United States. We heard testimony from different groups for this bill. I would almost guarantee you that some of those entities are large investors in these products. And so they have their own reason to stand financially, and they would gain from this bill. But the people that are going to be hurt are the people of Tennessee and the farmers. And so, I'd like for you to respond to that because this just seems like we're headed down a very dangerous path, limiting not just these chemicals, but all these other chemicals that my colleague mentioned.
Chairman Farmer, just go back.
Yes, sir. You're recognized.
Thank you. Well, we're not telling anyone that they cannot take any company to court. We're giving the company a defense because of the label that EPA has given them. And this idea that we're giving total immunity is just false. And I understand the original bill, the way it was drafted, there was words in there that gave people that impression. That's not my intent. There's never my intent to make sure that companies were never held accountable. But I will say this, that I enjoy eating. And I enjoy raising a safe, in America, we have the most abundant food supply in the world. And it's the cheapest food supply in the world, and it's the safest food supply in the world. And when the American farmer is no longer able to stay in business, we're going to start getting our food from another source. And we get our food from another source, it's going to be across the borders. And we're going to be going from Mexico or Brazil to Argentina, where they do not have the same safety standards that we have here in America. And you want to talk about being concerned about what's going in our bodies? When we're starting to ship our food into America rather than grow it in America, we're going to be in a lot worse shape than what you guys think we are now.
Yeah,
I am passionate about that. I don't mean anything directed at you, please.
And I get that, and I totally get it. And you know, my family's been farming business. You know, I come from a farming family, understand farming very well. I mean, I do represent an urban district, but trust me, I completely understand the farming business. I've got cows grazing those fields right now. And I have just not seen evidence. I mean, that's a nice soundbite to say that we're going to not be able to grow food in America. But the reality is that these other states where we have not passed this bill are still thriving, and farming is still doing extremely well. And the key to our success in America with farming, to me, is the innovation that we have had in our farms.
Sure.
And we must continue that innovation. And so part of the thing, too, is when you have bills like this, it also stifles the innovation to look for alternatives to these dangerous chemicals. And we've actually led the world in our innovations in farming, and I think this stifles that very thing. So for that reason, I'm totally against this bill. I continue to support farming and farmers, and I think by opposing this bill, I'm doing just that. Thank you.
Good. All right. Next on the list, I have, Chairman Todd. Sir, you're recognized.
Thank you, Mr. Chairman. Move previous question.
Second. Members, previous question has been called. Members, there is objection, so we'll be on the board. All those in favor of previous question, vote aye. Those opposed, vote no. Has there been a vote? Anybody like to change the vote? All right. Madam Clerk, if you take the vote, please. Excuse me. All right. Take the vote, please.
Mr. Chair, you have 14 ayes, 8 noes, and 0 present not voting.
Very good. Previous question prevails. So we're back on the question, and I have Chairman Doggett. Yes, be recognized, sir.
Mr. Chairman, I know there's been a lot of discussion today, and I know there was a motion made, but I would ask the sponsor of that motion, perhaps we could amend that motion to roll this bill to the second calendar of 2026 and perhaps have some type of study between now and then, because there's a lot of questions that have been asked and a lot of information that I think folks would like to be able to hear more from stakeholders.
Chairman Todd, sir, that's up to you. You've made the motion, it's a proper motion. We voted on it, but if that's, we can do whatever. I'm at the will of this committee. So,
Thank you, Mr. Chairman. I may have misunderstood what you said in your ruling a moment ago.
All right, I was wrong. Previous question did not prevail. There was not 2/3 vote on that board, so it failed. And then I've recognized Chairman Doggett, and Chairman Doggett has made a proper motion, and it has been seconded. So I guess we're on Chairman Doggett's motion to roll House Bill 809 to the second calendar of 2026. Is that what you asked?
It is. Do you want to check with the sponsor? I mean, if he's willing to comment or not, I
Just
don't know.
first, second calendar of 26. Got a motion.
Mr. Chairman and the committee, I know we've been through a lot for the last 3 weeks working on this. I appreciate your leadership and the committee's leadership, but I'm here to pass a bill, but I'm also here to work with the committee and make sure that we pass a bill and pass a legislation that is actually good for Tennesseans. So I will I'll lay on myself on the table of the chairman's discretion here.
All right, members, we have a motion to roll this bill to the second calendar of 2026. Is there any objection? All right. Have objection? All right, I've got one. Members, all those in favor of, do we need a second? All right, members, it'll be a voice vote. There's one objection. All those in favor of rolling House Bill 809 to the second calendar of 2026, say aye. Aye. Opposed, say no. No. All right, ayes have it. House Bill 809, item number 1 is rolled to the second calendar of 2026. Thanks, sir. brings us to item 3. Is Chairman Halsey around? Very good. We got House Bill 445. You've got a motion and second. And look, members, we have House Amendment 5985, sir. 5985. Do I have a motion? Do I have a second? You got a motion and a second. Members, we will go ahead and adopt that motion or adopt that amendment. All right, without objection. Yeah. Yeah, we will. Hold on. All right, members, we have House Bill 445, item 3 in front of us by President Halsey. He's got a first and second on the bill. I have a motion on Amendment 5985. Just need a second. All right, members, we want to go ahead and adopt that amendment. All right, any opposition? All right, seeing none. All those in favor of adopting House Amendment 5985 to House Bill 445, say aye. Aye. Opposed, say no. Ayes have it. Sir, you recognized.
Thank you, Mr. Chairman, and thank you, committee. And I especially want to thank Michelle Fogarty for last session. Several questions came up about restoring voting rights and how convoluted the existing law was. And Michelle took on that project and worked on this for several months. And I cannot just ignore the fact, and I have to tell you thank you, and I appreciate that very much. This bill straightens up a whole lot of convoluted things that we were dealing with under existing law. But as amended, this revises the process for restoration of rights of citizenship by creating one process for everyone seeking restoration of rights. Under current law, there's one process for somebody convicted after July 1st of 86, but before July 1st of 96, that's completely different than everybody else. This bill fixes that. Under current law, there's a separate process for persons convicted on or after July 1st of 96, which requires them to file a petition, but there was no petition. This fixes that. There was no way, at least in some judicial interpretation of the law, to separate voting rights out from the other rights of citizenship. So this bill defines what those rights are, and it allows an avenue for you to be able to get your voting rights back when you might not be qualified to get the other rights back. It defines what the rights of citizenship are. It defines what court costs are, and some of those things have not been changed from current law, like the requirement for fines and fees and court costs and restitution and child support before somebody's eligible to vote. It removes the presumption that restoration of rights should be granted upon the filing of a petition, but rather it makes it a preponderance of evidence that the petitioner is eligible. And this has upset some people, but under the basis that it might require a judge to have a hearing every time, and it could clog the courts up. But in this bill, the way it's written, it says if a signed petition comes in verifying and signing that these conditions have been met, the judge doesn't have to have a hearing. It can go ahead and sign off in his office and restore those rights. It directs the AOC to develop a form that's consistent to everybody and meets their needs, and that's pretty much what this bill does, is fix those kinds of issues.
Very good, members. We do have some testimony here. I had two folks sign up. I have Ms. Haynes and Ms. Ms. Lane, I believe. Are you ladies here? They are. Members, any objection going out of session and hearing from our guests? All right, seeing none. Ladies there, just have a seat, and we'll start to my left and move to the right. And you all have 2 minutes apiece, and then we'll have time for questions as well. And your mic's on, ma'am. You're properly recognized. Just introduce yourself to the committee, and I believe you've done this before, both of y'all. So you're recognized.
Okay. Good morning. My name is Jacola Lane. I'm a Davidson County resident and voting rights advocate at Campaign Legal Center, a nonpartisan nonprofit dedicated to strengthening our democracy. I am a Davidson County resident as well. I'm testifying in opposition to House Bill 445 because it makes Tennessee's already difficult rights restoration process even harder, especially for people who are not wealthy. I've helped many people navigate this process. I've seen how hard, expensive, and unfair it is. The process is so complex that people often think they need a lawyer, but most can't afford one. Those who try to file on their own often get rejected over paperwork errors, missing documents, or confusing legal language. Without help, most give up. This bill adds new barriers, like requiring a sworn statement, and also with records, especially old ones, they're often full of errors. I've seen people denied because of alias names they never used or child support records they couldn't control. Requiring people to swear those records are accurate puts them at a legal risk for things they didn't cause. Let's be clear. We're here because the coordinator of elections misapplied the Fall v. Goins ruling. The court said its decision was limited to one man's case, but the coordinator expanded it, making it harder for everyone in Tennessee to restore their voting rights. HB 445 would lock that unfair interpretation into law. Tennessee tried this court petition process before in 2006, and it failed. That's why the legislature created an alternative, because relying on the courts meant people's rights were restored based not on fairness, but on who could afford to pay. HB 445 brings us back to that broken pay-to-play system. At a time when we should be expanding democracy, this bill takes us backward. I respectfully urge you to vote no on HB 445. Thank you.
Perfect timing. Thank you for that. Ma'am, you're recognized.
Good morning, Chair Farmer, and members of the committee. My name is Keita Haynes, and I am the Senior Legal Counsel at Free Hearts, and I assist individuals with regaining their voting rights there. And first, I want to say, while I appreciate Representative Holsey's efforts in sections 1 through 5 of this bill to separate gun rights from voting rights, the rest of the bill creates new and unnecessary barriers that make it even harder for people to regain their voting rights. And it is because of this, I ask that you oppose HB 445. Since 2023, individuals have been faced with a two-step process to restore their voting rights. And while creating a one-step court process instead might seem like a simplified, streamlined process, however, in reality, it adds layers of complexity that make the process even harder to access. Under this bill, individuals must now prove they meet all eligibility requirements by preponderance of the evidence, a significant shift from the previous presumption standard. It also introduces new requirements like sworn statements that were never part of the process before. The expanded notice requirement, now involving 3 separate government agencies, creates unnecessary procedural hurdles, especially for those navigating this process without the help of a lawyer. Additionally, individuals who fall just above the indigency threshold and don't qualify for a filing fee waiver but still struggle financially will be forced into a pay-to-vote scenario, placing a direct barrier in the path of voting rights restoration. Furthermore, the codification of a court process for restoring voting rights will upend nearly 2 decades of a free, accessible administrative process. In 2006, the legislature intentionally moved away from a court-based process that, like the one in HB 445, was overly burdensome and created unnecessary barriers. Now, by reversing course and reinstating a judicial process, this bill takes us backwards, introducing filing fees, legal complexities, and procedural challenges that many individuals will struggle to overcome, and therefore I urge you to vote against HB 445. Thank you for your time, and I stand ready to answer any questions you may have.
And thank you for that. Representative Hardaway, you're recognized. And, excuse me, Representative Johnson, actually, you're on the list first. I apologize. Hardaway's trying to jump in front of you there. Yeah, he will. Let you all take that up. right, Representative Johnson, you're recognized.
Thank you, Mr. Chair. I appreciate you all being here because it kind of verifies what I felt, that 1 through 5, the sections were okay, but afterwards, what followed was far too expensive and far too difficult. So could one of you explain the difference since, how was the process for restoring rights before Falls versus Goins?
So before Falls v. Goins, the way that someone restored their voting right was through a free administrative process, and it was the certificate of restoration. Most of us that do this work call it the core. It was one page. You get it from Tennessee Department of Corrections, or either you could download it. You would take it to Tennessee Department of Corrections. They would fill out the part that said that your court costs had been waived or you had paid them. If you had the restitution, they would check the box and fill that out saying that you paid your restitution. And then there was parts where they filled out your offense and the date of your conviction and all that. The form was then turned into the coordinator of election. They would check the child support part if that was, if that applied to you. And if you met those requirements, then they would let the county elections division know to register the person to vote.
Okay, so it was verified by an officer of the courts that your status and all of that.
Yes.
So this new process that is more expensive, more difficult, more involved is not doing anything more, right? I mean, this was already being verified. Is that correct?
All of those things were already, I guess, verified by the Tennessee Department of Corrections. However, the Elections Division, when they got it, they did verify that the information was correct there, because we would have people that would turn in certificate of restorations, and then they would get something back saying, oh, well, you have another conviction in Marshall County that's you didn't fill out a certificate of restoration for. You need to do this. Oh, well, you have court costs. This, it's showing that this wasn't paid. So yeah, it was verified that way, but under this new process, the individual would be responsible for getting all of that information themselves, which they never did previously. They would have to get all of that information and then submit all of that information to the court. So I understand, that, Representative Halsey was talking about, the difference between the presumption and the preponderance of the evidence, but just to make it clear, like his explanation, does not relieve the person of having to still submit all of that information to the court. Yes, the court can, just grant a petition without having a hearing if there's no objection, but you still have to get all of that information to the court. And as Ms. Lane said, a lot of these records are really old. We've had situations just here in Davidson County where in the computer, it will say that a person has paid off their court costs. And it could be a case from 30 years ago. And we'll call there just to verify it. And they say, well, it says in the system that there's no court costs, but we need to go and pull the file from archives and we need to check. And when they get the files from archives, it could show that the person owes $3,000 in court costs that was never put in the system. So it's these types of things, that people will be forced to deal with, which is a problem, like I said, with these sworn statements, because if I don't know to call the clerk's office to verify what's on their website, then I'm just going to print that out saying I've paid my court costs, right, from 30 years ago, and then somebody could check it and it's just no, but then I've submitted a sworn statement swearing that this information is true and correct.
Okay, because what I see and what I know from our state works hard at reducing recidivism and things like that. And so what I know is letting people get back into society and getting a job and getting their voting rights back and being an active citizen is beneficial to preventing people from recommitting. And so it seems like we would want to do everything we could to make that process easy so that these folks can move on to being successful citizens. And it seems like this flies in the face of what our state is saying that we're trying to do, because that's just part of being a citizen who's doing what they are supposed to do. So it's concerning to me that we're putting this extra burden and putting this extra cost on something that doesn't cost anyone else anything, and we're putting the cost on folks that are having a struggle to start as they are released anyway. So thank you.
Representative Hardaway, you're recognized.
Thank you, Chairman. And thank you, ladies, for being here. You kind of hit on this, on how a person proves that they've paid restitution, paid their child support and their court costs. If you can't afford to pay those costs at one time, and if you don't have arrangements, you don't qualify for the indigency fund, what do you do? How do you get past that hurdle?
So as it relates to the requirements, which says that you have to have your court costs paid or waived, if you cannot pay your court costs all up front, and if you don't meet the indigency requirements in order to have it waived, then you don't meet the requirement to get your voting rights back. And then as it relates to the filing fee for this, again, there is an indigency requirement that you have to meet in order for the court to waive the filing fee in order for you to just be able to file a petition in court. Not even have it granted. This is just to file a petition in court. So filing fees across this state vary. Here in Davidson County, it's $159.50. In Shelby County, I'm sorry, not Shelby County, in Sumner County, it's $250. So it ranges from county to county what this filing fee is, and that's just a filer. That's not saying that your petition will be denied. And again, and as I mentioned, there are some folks who will fall just above that indigency cap and are still struggling financially. So if you have to pay $250 just to file this, but you are barely making ends meet and you don't meet the indigency requirements, then you're somebody that's not even going to be able to have the chance to get your voting rights back simply because you don't have that money that it's required to even file a petition. And again, and that was one of the reasons in 2006 when there was discussion in the legislature about this. One of the biggest things was the fact that people were having to pay a filing fee, and that's why they moved it to a free administrative process so that people would not have the financial barriers to even try to get their voting rights back.
All right, and you mentioned Falls versus Goings being misinterpreted by the coordinator and applied to the population at large as opposed to the one individual. Can you expound on that, please?
So Mr. Falls had a conviction in, I believe, Virginia, and he had received a pardon in Virginia. Mr. Falls had moved to Tennessee, and he wanted to register to vote. And Mr. Falls was told that he would not be able to register to vote because his pardon did not restore his full rights of citizenship. So they appealed to this, and it goes all the way to the Supreme Court. And the Supreme Court, looking at Mr. Falls himself, who had an out-of-state conviction, looked at the statutes and said that somebody like Mr. Falls would have to first get, a pardon or have their full rights of citizenship restored and then move through the certificate of restoration process. The coordinator of elections took that to mean that everybody in the state of Tennessee, whether you had an out-of-state conviction or whether you had an in-state conviction, had to also go through this two-step process in order to get your voting rights back. And so that's where we have been since 2023, because there have been people who were not aware of, this new two-step process or felt that, again, that it didn't apply to them. And so they just continued to do what's always been done, was the certificate of restoration. And the coordinator of elections was denying those people, telling them that they needed to complete the two-step process.
And just one more. You made reference to the difficulty of these various systems, computer systems, giving uniform information. Is there a risk if you get bad information that you're committing a crime?
Well, I mean,
if you take that information and it turns out it's incorrect. We had a case in Memphis where we had a young lady who took the word of a government agency and still ended up being prosecuted by the DA. So would you give me your insight on that, please?
There's your example right there. I mean, yes, like, and again, and that wasn't even a sworn statement, right? She just filled out the information based upon what the information that was, and actually they filled it out for her and she submitted it. So like I said, it wasn't even a sworn statement. So then now you're talking about a sworn statement where somebody is attesting to the fact that this information that they have received is true and correct. And so again, it's putting all of the burden on the individual with requiring all of these extra, barriers and hurdles in the criminal legal system. And a lot of people are familiar with that situation that you just described. A lot of people are familiar with that case, and it does have a chilling effect on whether people actually want to go through this court process in order to get their voting rights restored because of situations just like the one that you mentioned.
All right. Thank you, Mr. Chairman. I'm just assuming that all of this means that you don't think this legislation is ready for prime time and it can't be amended to make it right.
Well, I mean, I think that it could be amended. As I mentioned, sections 1 through 5 deal with separating gun rights from voting rights, and that has been an issue. Again, that was something that the Secretary of State decided to do, to say that full rights of citizenship included gun rights, and we have challenged that in court, and courts have disagreed, and courts have said that if you cannot get to your gun rights back, it does not prohibit you from being able to get your voting rights back. However, the Secretary of State is still not registering these people to vote. They're still holding them in limbo, even though there is a court order that is saying that these people can get their voting rights back. So sections 1 through 5 would deal with that. It would separate gun rights from voting rights. However, the rest of the bill that creates all of these hurdles and unnecessary barriers, like we don't need to do that. Like, I think that, I've testified in front of you all several times, have talked about these issues. You've heard other people come and talk about these issues. And, I don't think that we want to just pass something for the sake of passing something, and then for us to come back next year and have to get it right when we have the opportunity right in front of us right now to stop, to slow down, to really listen to folks that do this work every single day, all day. This is all that I do. Like, I am considered an expert when it comes to this. So let's stop. Let's look at this. Let's bring all the stakeholders to the table: advocates, lawyers, judges, DAs, AGs, clerk's office, everybody that this is going to impact. Let's bring everybody to the table and say, is this the most effective way to do this? What is good about this and what is bad about this? And let's get it right. Like I said, we shouldn't have to keep coming back year after year after year because we are sitting here telling you now that this is not going to work and that this is going to cause problems and that we need to think about this. Let's talk about it and let's get it right the first time instead of having to pass something for the sake of passing something and having bad policy that we have to come back and correct.
All right. Thank you, ma'am. Thank you, Chairman.
Thank you, Representative Hardaway. Representative Bolso, you recognize.
Thank you, Mr. Chairman. I move that we return to session.
Right. Members, that's a proper motion, proper second. Any objection? All right, seeing none. Thank you all for being here. Chairman Halsey, it's your time to shine.
I'm sorry?
This morning. I said it's your time to shine this morning. Any remarks for the members before we open
No,
it up
sir,
for questions?
I don't. I have folks here to speak on this if you wanted to hear it that would oppose what you heard.
All right, questions been called. Any objection? All right. We're on the board. Members, all those in favor of the previous question, vote aye. Opposed, vote no. Is there a member voted? Anybody will change the vote? We're on previous question. All right, Madam Clerk, take the vote.
Mr. Chair, you have 15 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members are going to be voting to send House Bill 445 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Is there a member voted? Anybody like to change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 15 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 445 as amended is moving to calendar and rules.
Thank you, Chairman. Thank you, committee.
Sir, and you also have another bill, your resolution here, H.R. 182. No amendments. It's moving to calendar after this. Motion in a second. You're properly recognized.
I apologize. I thought we were pushing the time limit here. There's a young college student in my district named Lakey Derrick. She's working on her master's right now. She came to me and said, would you run this House resolution? And I looked at it and I said, yeah, I'd be glad to. And what it does is it just celebrates the nuclear family and dedicates this month of June coming up of this year as a nuclear family month. And that's what it does.
Members, any questions for Chairman Halsey? Question's been called. Any objection? Seeing none. Looks like we're ready to vote to send House Joint Resolution 182 to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has there ever been voted? Anybody like to change their vote?
Hardaway, I can't believe you're against my resolution.
All right. Representative Towns, is your okay, there you go. All right, if you take the vote, Madam Clerk.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. HJR 182 is moving to calendar and rules. Very good.
Thank you, sir.
Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. Members, we have with us special guest here from home. Students with the Ingram Scholars Program at the University of Tennessee Southern, led by Mr. Pat Ford. If y'all would stand up and let us recognize you. Thank you for being with us.
Very good. Members, that brings us to item 5, and without objection, we're going to roll item 5 23 spaces. Without objection, item 5 rolled 23 spaces. That's House Bill 4. That brings to item 6, House Resolution 11 by Representative Bolso. You got a motion and a second. Sir, you're probably recognized.
Thank you, Mr. Chairman. This is the rules package that comes to us from the Supreme Court of Tennessee every year.
The previous question has been called. Members, any objection to the question? Seeing none, all in favor of House Resolution 11 moving to calendar rules, vote aye. Opposed, vote no. Has every member voted? Anybody like to change the vote? Well. All right, members, Madam Clerk, if you take the vote.
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations, Representative Bolso. House Resolution 11 is moving to calendar and rules. That brings to item 7, House Resolution 12, also by Chairman Bolso. You got a motion and a second. You're properly recognized. Question's been called. Members, any objections to the question? All right, seeing none. Members, all those in favor of moving House Resolution 12 to calendar and rules, vote aye. Opposed, vote no. Has every member voted? Anybody like to change their vote? Very good. Madam Clerk, take a vote.
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Congratulations once again, sir. House Resolution 12 is moving to calendar and rules. That brings us to item 8, House Bill 587 by Representative Scarborough. Second. Is he here? He may not be.
Thank you, Mr. Chairman.
Oh, there he is. Okay. Sir, you got a motion and a second. You're probably recognized.
Thank you, Mr. Chairman. 2 years ago, the General Assembly wisely amended the Racketeer Influence and Corruption Act, better known as the RICO Act, by adding multiple offenses to crimes, including statutory definition of racketeering activity. The bill simply adds 3 more crucial offenses to that list. The bill will give law enforcement and district attorneys the tools they need to disrupt, dismantle criminal gang enterprises. And I'll stand for questions, sir.
Members who have any questions for Representative Scarborough, House Bill 587.
Probably.
I do have a hand up. I had Representative Johnson. Question's been called. You want to? Question's been called. Any objection? All right. I've got 3 hands. Members, all those in favor of previous questions, vote aye. Opposed, vote no. They're on the board. We're voting previous question. All right, Madam Clerk, take the vote, please.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members are voting to send House Bill 587 to calendar and rules. All those in favor vote aye. Opposed, vote no. Has that member voted? Anybody like to change the vote? All right, Madam Clerk, if you please take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 587 is moving to calendar and rules. All right, members, and once again, it's that time of the year. Representative Scarborough, you have other items on the calendar. I'm just going to go ahead, members, without objection. We're going to move to item 61, House Bill 370. Is that? Sir, you've got a motion in a second. There's no amendments on that one. That's item 61, House Bill 370.
Thank you, Mr. Chairman.
Motion.
And you've got a motion. You're probably recognized.
Mr. Chairman, this merely adds to the harassment to where it now is also an offense to do so in person, and I'll stand by for questions.
All right, any questions for Representative Scarborough? The question has been called. Any objection to the question? Seeing none, members, look like we're ready to vote to send House Bill 370 to Finance, Ways, and Means. Everyone in favor, vote aye. Opposed, vote no. Has every member voted? Anybody like to change their vote? Jesus. All right. Madam Clerk, if you would please take the vote.
Mr. Chair, you have 19 ayes, 1 no, and 0 present not voting.
Very good. House Bill 370 is moving to Finance, Ways, and Means. Members, that brings us to the next item. It's item 62, House Bill 371, also by Representative Scarborough. So you have a motion and a second on the bill. I see 2 or 3 amendments here. It looks like the latest amendment filed was 6841. And we may need 2, I've been told. So, members, we may need to adopt House Amendment 6783 and 6841.
Second.
So a motion and a second on 6783. Any objection to adopting that amendment? All right, seeing none. Members, we're voting to adopt House Amendment 6783 to House Bill 371. All those in favor say aye. Aye. Opposed, say no. Ayes have it. That amendment is adopted. 6783. Now we need a motion and a second on House Amendment 6841. Second. Members, any objection to adopting that amendment? All right, seeing none. All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we've also adopted House Amendment 6841. Without objection, we're going to roll those 2 amendments into one. Without objection. All right, Representative Scarborough, you're recognized on the bill as amended.
Thank you, Chairman. This bill simply mandates anyone convicted of a Class A misdemeanor to complete a cognitive behavioral training course unless the judge deems the course is inappropriate for the offender. I'll stand by for any questions.
Members, any questions? Seeing none, we ready to vote? Any objection to the question? All right, seeing none, members, we're ready to vote to send House Bill 371 to Finance, Ways, and Means as amended. All those in favor vote aye. Opposed, vote no. Everyone voted. Anybody like to change their vote? All right, Madam Clerk, will you take the vote, please?
Mr. Chair, you have 22 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 371 as amended is moving to Finance, Ways, and Means. That brings us to item 63, also by Representative Scarborough. That's House Bill 527. There are no amendments. Sorry, you're properly recognized.
Thank you, Mr. Chairman. This will eliminate any mitigating factors for the parole board to consider when considering the parole of an individual. Currently, there's 22 offenses that only allows that. This will bring in the remaining felonies for that same consideration to where, again.
All right. Question's been called. Any objection? All right. All right. Members, we have objection. We're on the board. All those in favor of the previous question, vote aye. Opposed, vote no. Does everyone vote? Anybody like to change their vote? All right, Madam Clerk, if you would take the vote.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. We're going to be voting to send House Bill 527 to calendar and rules. All those in favor vote aye. Opposed, vote no. Does every member vote? Anybody like to change their vote? All right, Madam Clerk, if you would hold.
Mr. Chair, you have 15 ayes, 6 noes, and 0 present not voting.
Congratulations. House Bill 527 is moving to calendar and rules, sir. Thank you. That brings that also, as the Scarborough show here, item 64, House Bill 671. Members, you've got, we got a motion and a second on the bill. Look, I'm saying Amendment 4524 here. Sir, is that an amendment you want to move forward with?
Yes, sir.
Members, we'll go ahead and adopt that amendment. Any objection? All right, seeing none, all those in favor of adopting House Amendment 4524 to House Bill 671, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill, House Bill 671 as amended, and you're properly recognized.
This bill is going to provide professional bondsmen to file a petition for release from their obligations in an open hearing that would show good faith efforts that have been made to locate the defendant. I'll stand by for questions.
Members, any questions for Representative Scarborough? All right, Representative Hardaway, you recognize.
Thank you. Clarification, when you say release from their obligations, that means that they will or will not forfeit a financial bond.
Representative Scarborough, you recognize.
I'm sorry, repeat that again, sir.
If they're released from their obligation, would they have to pay any money to the courts for the individual not showing up?
It's not my understanding that they will not have to. This is going to be clarifying expectations and responsibilities for the bondsman, sir.
All right, thank you.
Any additional questions for the sponsor? All right, seeing none, any objection to the question? All right, seeing none, members, looks like we're ready to vote to send House Bill 671 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Any for every member voted? Anybody want to change the vote? Madam Clerk, if you take the vote, please.
Mr. Chair, you have 19 ayes, 2 noes, and 1 present not voting.
Very good. Congratulations, sir. House Bill 671 as amended is moving to calendar and rules. All right, members. All right, without objection, we're going to move. Yes, ma'am. You're recognized.
I feel like, I know that we have a lot of bills, we're moving fast, but committee is where we are supposed to discuss and debate and understand the bills. And so it's frustrating when we have questions that may not mean that we're against the bill, just clarifying questions that we need that we many times are not allowed to ask those questions. So isn't that where we're supposed to have a discussion on these bills?
I would agree partially, but we all serve on a committee. The calendars are generated a week prior. We do have time, and I speak with, and I know plenty of others, members call me, and I speak with them and ask them questions about their bill days before subcommittee or full committee. So we're not without an opportunity. None of us are without an opportunity to talk to anybody in this General Assembly about any bill that's calendared.
For my constituents, they're the ones that need to hear this, not our personal phone calls to each other.
Very good. All right. We're moving on. Members, without objection, we're going to move back to item 9. That's House Bill 184 by Representative Hardaway. So I don't see any amendments here, and I also see that it's been general sub in the Senate. What would you like to do with this?
Mr. Chairman, I'd like to get it out of here, and then I'll hold it. They're going to bring it out, if not this year, next year.
Leader Lambert, you recognize.
Move this bill to the first calendar of next year.
That's proper motion, proper second. Any objection? Got objection. Members, we're voting on the board to move House Bill 184 to the first calendar of 2026. All those in favor vote aye. Opposed, vote no. Has everyone voted? Anybody like to change the vote? All right, very good. The motion prevails. House Bill, excuse me, I'm going to have the clerk. Madam Clerk, you take that vote. I apologize.
Mr. Chair, you have 16 ayes, 6 noes, and 0 present not voting.
All right. Representative Hardaway, the motion prevails. House Bill 184 is going to be moved to the first calendar of 2026. That brings us to item 10, House Bill 361. Sponsor has requested this to be moved to the hill of today's calendar, as I understand it. Excuse me?
But not this one. This is a simple one.
Oh, okay. I'll retract that.
Yes, sir.
House Bill 361, members, by Representative Parkinson.
If I can get my Democrats to give me a motion in a second, that would be great.
All right, you've got a motion in a second.
Thank you. Thank you, sir.
Representative Parkinson, also see House Amendment 4221, sir.
Yes, sir. Yes, sir. That amendment just simply makes this statewide. And if you want me to,
So you've got a motion. Members, we have a second. Members, we want to go ahead and adopt that amendment. Any objection to adopting House Amendment 4221? All right, seeing none. All those in favor vote aye. Opposed, vote no. Oh, excuse me. All those in favor say aye. Aye. Opposed, say no. Ayes have it. All right, now we're back on the bill as amended, sir. House Bill 361. You're properly recognized.
Thank you, Mr. Chair, and thank you, committee. What this bill simply does is says that it codifies in the law that any court that is hearing a domestic violence case or an assault case, they have the ability to issue an order of protection. That's simply what this bill does.
Members, any questions for Representative Parkinson? Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. Is this a may or a shall on the courts here if we're making it statewide?
Representative Parkinson, you're recognized.
It's a may. If that court sees fit, if they want to do it, they can do it. Yes, sir.
Thank you.
Very good. Leader Lamberth.
We had several members earlier that wanted to ask a lot of questions on simple bills that we've all studied. I wanted to give everybody plenty of opportunity to ask questions on this one.
Very good. Members, any additional questions?
Good. There we go.
Representative Hardaway, and then Representative Johnson. You recognize.
Oh, I thought you said Hardaway.
Hardaway, he beat you this time.
All right. Is there anything that the sponsor wants to share that he hasn't shared already?
Representative Parkinson, you're recognized.
Thank you, sir. No.
Very good. Representative Johnson.
Yes, as we noticed, I didn't have a question on every single bill, but I certainly had serious questions on some bills. So I just thought it was interesting that this one, we had a whole lot of time on the front end and nobody called a question really quickly. But so I do think that I completely understand your bill. Any court that's hearing a criminal case that wants to do an order of protection can do that. It's not limited just to a particular court. Is that correct?
President Parkinson.
Yes, sir. Thank you, Mr. Chair. Thank you, Representative. It is limited, honestly, to courts that are hearing domestic violence case or assault cases, things of that nature, where order of protection is necessary.
Okay, but not as it was originally to one court that did orders of protection.
Right, and Mr. Chair.
You're recognized.
Okay, and thank you. And what it was there were some questions, from some of the courts as to whether or not they had the ability to do it. So we're codifying and making it clear that those courts have the ability to do it.
Thank you.
Very good. Representative Garrett, you're next on the list.
Thank you, Mr. Chairman. I'm concerned on a couple of levels with this piece of legislation. That an order of protection by its nature is civil matters, right? You're in civil court, you're not in criminal court, you're seeking an order of protection because something happened. Usually it's in the family law arena. And typically, if there's not a divorce pending or the parties aren't married, they do set some sort of child support for the purposes of that order of protection, because sometimes the person seeking the order of protection might be seeking the exclusive possession of the home if they share that. Therefore, whomever the order of protection is granted against has to leave. Sometimes there's a support order for that purposes. So I've got a little bit of concern that you're not allowing the criminal court to have anything as related to child support, visitation, et cetera, when some of these order of protections do just that. And also in criminal court, can you, and this may be a question for legal, but usually there's a no contact order. There's something that the criminal court already has jurisdiction to prevent contact with someone in this various reasons. So I'm curious, why the double lanes? We don't need it for a civil matter that's usually exclusive to the civil world to be confused what happens in the criminal court when the criminal court already has the authority to execute or determine protection orders. So that's why I'm concerned that we're meddling the two when the two doesn't need to be meddled.
President Parkinson.
Thank you, Mr. Chair, and thank you, Chairman Garrett. The judge that brought this to me said that there was a little bit of ambiguity as to whether or not she could actually issue those orders of protection, and she wanted to because she had both parties in front of her, be able to issue it then without there having to be, if it's needed, without there having to be an extra step. This had nothing to do with child support or anything like that.
Representative Garrett.
Well, thank you, Mr. Chairman. I understand that, but what if that's an issue before the court that she orders an order of protection that removes someone from the house, and there needs to be a child support order in place to make sure that child is provided for, and we're giving her no jurisdiction to decide that in the criminal world. That's why I think we're meddling the two courts, and the orders of protection are completely usually in the civil side of the case. So that's my issues with the bill. I can't support it in its current form because I don't believe it addresses what your judge wants to happen.
Good. Representative Parkinson, you're recognized.
And thank you for that. And I understand your concern, but the child support matters are handled in the child support cases. This is for judges that are hearing domestic violence cases, judges that are hearing assault cases, and so on and so forth.
Representative Garrett.
Thank you, Mr. Chairman, and I understand that, Representative Parkinson. I respect you. I'm not trying to scuttle the bill, but what I'm trying to tell you is it's not doing what you're intending to do, because in an order protection sense, there can be issues that relate to child support, and you're not allowing the judge in the criminal court arena in your bill to do just that. And that's a problem with your bill. If you indeed want to adjudicate those issues, they should have the ability to make those rulings in criminal and both civil court. Your bill doesn't allow the criminal court judge to do that. That's my issue with your bill. I'm not saying it's not a good idea what you're trying to do. I just don't think you get there.
Okay. So, Representative Parkinson.
I'm honestly not, so I'm honestly not clear on what the counselor is saying. And here's why I'm saying it. Because, we're talking about, it's already, so, I think in a lot of cases, it is already assumed that those judges that are hearing domestic violence cases, that are hearing domestic violence cases can issue orders of protection. But it wasn't clear everywhere. And so all we're doing with this legislation is making it clear what possibly already exists in the law. And I would be happy to go out of session to legal because I do want to make sure we address your concerns.
Members. Representative Travis.
Thank you, Mr. Chairman and Representative Parkinson. Would you, because there is some issues here that I see, would you be able or would like to roll this to the first calendar of next year?
Representative Parkinson.
Thank you, Mr. Chair. I would actually prefer to go, if you, Mr. Chair, and with your indulgence, we can go out of session with legal so we can answer those questions that the representative might have had.
With regards to Representative Garrett's questions?
Yes, sir. Yes, sir.
All right, just hang tight. Leader Lambert, you recognize.
Thank you, Mr. Chairman. And I was going back forward legal. Mr. Chairman, are we definitely going to meet tomorrow in this committee?
Yes, we are.
Mr. Chairman, I would move that we roll this to the heel so that it can be heard tomorrow. Let Representative Garrett, Representative Parkinson get together. I think there's one sentence that and legal is kind of going back and forth over there looking at it, where Representative Garrett makes an excellent point that if it's going to be heard in both courts, then in custody and child support and everything else should be able to be heard in both if they're hearing the order of protection. But my motion at this time is just motion to move this to the heel of the final calendar so that it could potentially be heard tomorrow and work on some sort of an amendment. It's a good idea in my humble opinion. So that's my motion.
All right, proper motion, properly seconded. Members, all those in favor of moving House Bill, this is the hill of this calendar. And members, any objection to moving House Bill, item 10, House Bill 361 to the hill of this calendar? All right, seeing none.
Okay. Thank you, Mr. Chair.
Sir.
Thank you, committee.
That brings us to item 11, House Bill 854. That's by Leader Lambert. Leader, you ready? If you need some time, you're ready.
Mr. Chairman, I'm always ready.
Members,
let's roll.
You are. House Bill 854, members. I got a motion and a second. Members, there's also House Amendment 4431.
Second.
So you've got a motion and a second on that amendment. Is that something we need to go ahead and adopt? Or?
Yes, sir, Mr. Chairman.
Members, any objection to adopting House Amendment 4431 to House Bill 854? All right, seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on House Bill 854 as amended. Leader Lambert, you're properly recognized.
Thank you, Mr. Chairman. Reliable hearsay is utilized in many proceedings within the court system, as you know. This would just allow for reliable hearsay to be utilized in a bond hearing.
Members, any questions for Leader Lambert? All right, seeing none. Any questions been called? Any objection to the question? All right, seeing none. Members, looks like we're going to be voting to send House Bill 854 as amended to calendar and rules. All those voting in favor, vote aye. Opposed, vote no. Has that member voted? Anybody change your vote? All right, Madam Clerk, if you'd please take the vote.
Mr. Chair, you have 20 ayes, 1 no, and 0 present not voting.
Very good. Thank you, members. House Bill 854 as amended is moving to calendar and rules. That brings us to item 12. That's House Bill 99 by Representative Bolso. And I don't see any amendments, and you're properly recognized, sir.
Thank you, Mr. Chairman. Members, this is a bill that we actually passed last session. The 113th General Assembly got placed behind the budget but was not funded. It simply seeks to strengthen our unlawful photography statute, as we've done several times already this year. Specifically, it increases the penalties from Class A misdemeanor to Class E felony, and it also provides for aggravating circumstances when a minor is used or is involved in unlawful photography. With that, Mr. Chairman, I'm ready for questions.
Very good. Question's been called. Any objection? Seeing none, members are ready to vote. Send House Bill 99 to Finance, Ways, and Means. All those in favor vote aye. Those opposed vote no. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, take the vote, please.
Mr. Chair, you have 19 ayes, 0 noes, and 1 present not voting.
All right. House Bill 99 is moving to Finance, Ways, and Means. Brings us to item 13, House Bill 327. Representative Bolso. I don't see any amendments, sir, and you're properly recognized.
Thank you, Mr. Chairman. This is a bill that comes to us from the Naming and Designating Committee, and it seeks to designate June, July, and August as the months of life, liberty, and the pursuit of happiness in honor of the 250th anniversary of the signing of the Declaration of Independence next year. With that, Mr. Chairman, I'm ready for questions.
Members, any questions for Representative Bolso? Seeing none. Any objection to the question? I've got objection. Representative Johnson, you recognize.
Thank you. So is this the bill that names June, July, and August as certain months?
Representative Bolso?
Thank you, Mr. Chairman. Yes, it designates June as the month in which we'll designate it as the Celebration of Life Month, in part because that was the month, obviously, where the U.S. Supreme Court issued its Dobbs decision on June the 23rd of 2022. It designates the month of July as a Celebration of Liberty Month because that obviously was the month during which the Declaration of Independence was signed. And then it designates August as a celebration of Pursuit of Happiness Month because that's typically the month where children return to school and focus on gaining ground in their pursuit of happiness.
Very good. Representative Johnson.
I don't know, maybe June should be happy this month when they get out of school, or May. But I guess my concern is I think we just named June Nuclear Family Month. Many of us know June as Pride Month. Isn't this going to get confusing with all these different designations for the same month?
Thank you, Mr. Chairman. Actually, no. If you look at page 714 of our Tennessee Blue Book, you'll see that we already have certain months designated as months where we recognize certain groups or events. And so it's all categorized very nicely. And the month of June is probably already in our Blue Book designated for a number of other things, as would be March and April. As our specific days of the year. So it will not be confusing. It's just a question of adding these designations to months that are already in the Blue Book.
Very good. Any additional questions? Representative Hardaway.
Thank you, Chairman. My birthday is June 18th, so I want an amendment that would also make it a celebration of G.A. Hardaway Month.
Very good. Very good. Thank you. Question's been called. Any objection to the question? All right. Seeing none. Members are voting to send House Bill 327 to calendar and rules. All those in favor vote aye. Opposed vote no. Is there a member voting? Anybody like to change the vote? All right, Madam Clerk, will you please take the vote?
Mr. Chair, you have 16 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 327 is moving to calendar and rules. And members, we could move out of order without objection to item 47. Representative Helton Haynes, chair lady there, has been waiting patiently, and I apologize for missing you, ma'am. So you got a motion and a second on your bill, and I'm looking at House Amendment 5619, members, so we want to go ahead and adopt that amendment. Got a motion and a second. Any objection to adopting House Amendment 5619 to House Bill 490? All those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Mr. Chairman. Pursuant to McNabb versus Harrison, the Tennessee Supreme Court decided that Article 6, Section 4 of the Tennessee Constitution requires a municipal judge to be a resident of that municipality for a period of 1 year prior to the election. Amendment 5619 rewrites the bill and does 4 things. It prohibits the disqualification or removal of a municipal judge who was duly elected or appointed to office prior to March 7, 2025, and who is qualified for such office under the laws and interpretations in effect at the time of such election or appointment, due to a residency requirement during the term of office to which the judge was elected or appointed. It requires that any such municipal judge be deemed a de facto officer whose acts, judgments, and decisions are valid and binding during the completion of the judge's term. It specifies that the requirement for a municipal judge to be a resident of that municipality for a period of 1 year prior to election, established by the Tennessee Supreme Court in McNabb v. Harrison on March 7, 2025, shall apply prospectively and be enforced beginning with the next regularly scheduled election for any affected municipal judgeship. It specifies that such does not exempt municipal judges from any other qualification or eligibility requirement. And with that, Mr. Chairman, I stand for any questions.
Very good. And ma'am, I noticed you did have we have a Mr. Litchford. Mr. Litchford's here. Does he need to testify?
If there's any really technical questions, yes, but otherwise, no.
Okay, good. Very good. Members have any questions for Representative Helton Haynes? I have Representative Hardaway had his hand up there. Members, if we could just, Representative Hardaway, you're recognized.
Thank you, Mr. Chairman, in lieu of having a birthday month. Chair Lady, so in essence, you could have an appointment for a judge, but the judge would be obligated to move into the district before the next election, if he or she wanted to run.
Yes, they would have to be a resident for at least a year.
All right. Thank you, ma'am.
Any additional questions? All right, seeing none. Members, any objection to the question? All right, seeing none. Members, looks like we're ready to vote to send House Bill 490 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Is there a member vote? Anybody like to change the vote? Madam Clerk, if you please take the vote.
Mr. Chair, you have 21 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 490 is moving to calendar and rules as amended.
Thank you, Mr. Chairman and committee.
All right, members, without objection, I'm seeing some other folks that are not on this committee out there. Item 21, that's House Bill 634 by Representative Clemens.
Motion.
Sir, we also have House Amendment 4453, members. Is that something you'd like to move forward with?
That makes the bill, Mr. Chairman.
So you've got a motion and a second on that amendment. Members, any objection to adopting House Amendment 4453 to House Bill 634? All right, seeing none, all in favor, vote, say aye. Aye. Opposed, say no. All right, Representative Clemens, we're back on your bill as amended.
Thank you, Mr. Chairman and committee. I sincerely appreciate it. This bill would create a conservatorship management task force to review the provision and direction of available resources to promote effective and successful conservatorships statewide. They would produce a report to the Department of Aging and Disability, or Disability and Aging, by the end of this year. Right now, the number of conservatorships in Tennessee is unknown, and so is the amount of assets managed by conservators statewide. While different counties have different training, we just want to see if we can get a report to the department and make sure that we know what's going on statewide, and see if we can generate some consistency across the board to better protect vulnerable Tennesseans through this important process.
Very good, and thank you for that explanation. Members, any questions for Representative Clemens? Seeing none. Well, seeing one. Representative Johnson, you wave off. You good? All right, you're recognized.
I can do it. Just so the impetus for this bill was to make sure those folks who were vulnerable were getting the attention that they needed. Is that what you're working here?
Representative Clemens.
Yes, thank you. And so, yeah, this bill comes to me from Senator Ackberry and some others doing this work across the state of Tennessee. And the goal here is to make sure that we streamline the process and make sure we have a good a feel for the amount of assets that are being handled across the state of Tennessee, how many conservators there are. There's different training in different counties. So we just want to see if we can't get this, provide some more transparency to this really important process that benefits a lot of people, but we want to make sure we're protecting vulnerable Tennesseans as well.
Very good. Members, any additional questions for our sponsor? Question's been called. All right, any objection to the question? Seeing none. Members, all those in favor of sending House Bill 634 as amended to government operations, vote aye. Opposed, vote no. Every member vote, anybody like to change the vote? Madam Clerk, will you please take the vote?
Mr. Chair, you have 17 ayes, 0 noes, and 2 present not voting.
Very good. Congratulations. House Bill 634 as amended is moving to GovOps.
Thank you.
That brings us, members, if we could, without objection, to item 19, House Bill 874. Motion. Chairman Martin's been patiently waiting there. Sir, you've got a motion and a second on your bill. You have House Amendment 5512.
That is correct, Chairman.
Members? And you've got a motion and a second on your amendment. Is that an amendment you'd like to go ahead and adopt?
Yes, sir.
Members, any objection to that? Seeing none, all those in favor of adopting House Amendment 5512, House Bill 874, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Yes, sir. Thank you, Committee and Chair. This bill came from my local DA and his lead investigator. They've been working toward countless convictions on child exploitation cases. This bill, that's better known as the Tennessee Protection of Children Against Sexual Exploitation Act, looks to close a loophole that they found in the process that's been hindering some of their cases. Currently, this bill would prevent electronic service providers from contacting child sexual exploitation suspects who are currently under investigation, whose records have been subpoenaed for search warrant from the judge already. ESPs consider any company that do online services such as email, internet service providers, social media apps, things like that. So what's currently happening is they might go and request those records, and those groups or companies are contacting the individual, letting them know that their information is being requested. So what this does, it gives the suspect time to destroy evidence. It hinders the investigation, making it virtually impossible to get these people on the front end if they're destroying the evidence before we get to them. It's also making the victim known to the suspect, and then it also puts our law enforcement at risk once they do show up to get the information from those folks if they've known or been tipped off on it. And with that, I stand ready for question, and we do have folks that can speak out on it as well.
Members, do we have any questions for our sponsor? All right. Do we want to go out of session and hear from testimony, or go to have questions of the sponsor? All right. Excuse me. Leader Lamberth.
Move previous question.
All right. Previous question has been called. Members, any objection to the question? All right. There's objection. We're on the board. All those in favor of previous question, vote aye. Those opposed, vote no. Has everyone voted? Anyone like to change their vote? All right, Madam Clerk, you take the vote, please.
Mr. Chair, you have 13 ayes, 6 noes, and 0 present not voting.
Previous question prevails. Members, we're back on the bill. All those in favor voting, all those in favor of sending House Bill 874 as amended to calendar rules, vote aye. Those opposed, vote no. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, if you would, take the vote, please.
Mr. Chair, you have 16 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 874 is moving to, as amended, is moving to calendar rules.
Thank you, Committee and Chair.
And members, the next bill, next item, actually item 20, I see Representative Reeves down there, House Bill 468. And I see House Amendment 4927.
Yes,
members.
sir.
So you got a motion and a second amendment. Is that something you'd like to go ahead and adopt?
Yes, sir.
Put it on. Members, any objection to adopting House Amendment 4927 to House Bill 468? Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. All right, back on the bill as amended. You're properly recognized.
Thank you, Mr. Chair. This bill aligns recklessly firing into a motor vehicle with recklessly firing into a home, and this was brought to me by a local circuit court judge. If occupied, the offender can be charged with a Class C felony, and if unoccupied, the offender can be charged with a Class D felony. Currently, firing into a motor vehicle, occupied or not, is a Class E felony. And with that, I'll open for any questions.
Very good. Thank you for the explanation. Members, any questions for Representative Reeves? Seeing none, we ready to vote? Any objection to the question? All right. Members, all those in favor of sending House Bill 468 as amended to Finance, Ways, and Means, vote aye. Opposed, vote no. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, if you would take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 468 moves to Finance, Ways and Means. 468 as amended moves to Finance, Ways and Means. And sir, I believe you have one more. Just give one moment. We'll get to it. Members, any objection to moving to item 48? All right, seeing none. Sir, members, moving to item 48, House Bill 748. You've got a motion and a second. I don't see any amendments on this, so you're properly recognized.
Thank you, Mr. Chair. This was actually brought to me by a local municipal court judge in 2004. The Tennessee legislature adopted the Municipal Court Reform Act, and it stated that $1 of every filing be forwarded to the municipal court clerk to provide training and continuing education courses for municipal court judges and court clerks. Due to inflation over that period of time, the purchasing power of that dollar has been significantly reduced, and so what this bill does is set that at $2 instead of $1. And with that, I'll take any questions.
Members, any questions for the sponsor? Any questions? Questions been called? Any objection to the question? All right, seeing none. Members, also will be voting to send House Bill 748 to Finance, Ways and Means. All those in favor, vote yes. Opposed, vote no. Has everyone been voting? Anybody like to change the vote? Madam Clerk, if you would please take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations. House Bill 748 is moving to Finance, Ways and Means. Thank you.
Thank you, Mr. Chair and committee.
Members, that brings us to back to item 14, House Bill 706 by Representative Travis. Sir, I see House Amendment 4354. Members, is that something we'd like to go ahead and adopt? Any objection? Seeing none. All those in favor of adopting House Amendment 4354 to House Bill 706, say aye. Aye. Opposed, say no. Ayes have it. Now, sir, you're probably recognized on your bill as amended.
Thank you, Mr. Chairman and committee. House Bill 706, it creates 10 additional Assistant District Attorney General positions and 10 criminal investigators positions and 10 Assistant District Public Defender positions to be designated in judicial districts containing a state correctional institution. And I'll stand for any questions.
Very good. Any questions for Representative Travis? Representative Towns, you recognize?
Thank you, sir. Mr. Representative, are those dispatched across the state or in a certain area? How does that break out?
Yes, every judicial district. Oh, sorry.
No, go ahead. Go ahead.
Every judicial district in the state of Tennessee who has a correctional institution.
Okay.
A state correctional institution.
Will receive some of that manpower.
Yes, sir.
Okay, thank you, sir.
Representative Johnson, did you have your hand up? No. Okay. Members, any other additional questions for Representative Travis? All right, seeing none, we ready to vote? Any objection to the question? All right, seeing none. Members, we're voting to send House Bill 706 as amended to Finance, Ways and Means. All those in favor, vote aye. Opposed, vote no. Several men voting. Anybody like to change the vote? Right, very good. Madam Clerk, if you go ahead and take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations, Representative Travis. House Bill 706 as amended is moving to Finance, Ways and Means. Sir, you recognize.
Thank you, Mr. Chairman. And up front, I've noticed our Safety Tennessee guys are here. Thanks for breakfast last week, and we appreciate you being here, and it's good to see you guys.
All right, very good. Members, we could, without objection, if we could move to item 31. That's by Representative Alexander. There are some, I believe she has some folks here. House Bill 1255, item 31. And you've got a motion and a second on that.
Thank you, Chairman, and thank you, committee.
House Amendment 5313, is that one?
That is correct.
Members, I've got a motion and a second. Any objection to adopting House Amendment 5313 to House Bill 1255? All right, seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're properly recognized.
Thank you, Chairman. This bill, last year, we brought to you April's Law. which would protect children and keep them from being put back into abusive homes. This year, we're just adding a few extra things to that bill. And we've used, thanks to the Tennessee Bar Association, the Family Law Division, Office of the Courts, and DCS came together and studied this bill and tried to make the right choices so that our courts would not put kids back into harm's way. And we did that through 3 or 4 things. I can mention them, or you all may already know it, whichever way you want to go.
Members, any questions for Representative Alexander? The question's been called. Any objection to the question? Not seeing none. Members, looks like we're ready to vote to send House Bill 1255 as amended to calendar and rules. All those in favor vote yes. Opposed, vote no. Every member voted. Anybody like to change the vote? All right, Madam Clerk, if you would please take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Members, House Bill 1255 as amended is moving to calendar and rules.
Thank you.
All right, and I apologize for the break there. Okay, if we, members, if we could move to item, what item was that? 36. I saw Representative Reedy sitting there. And we're hopping around. I apologize about that. So that's item 36. That's House Joint Resolution 53 for everyone. Information. Sir, and you've got a motion in a second. You're probably recognized.
Thank you, Mr. Chairman and committee. Of course, it was last session we had, it was this same Tennessee constitutional amendment request. It was HJR 38 in the House. It was SJR 904 by Senator Stevens. It passed out both. It did not get funded, and so I am back this year with HJR 53, just requesting that for consideration that we amend our Article 1, Section 26 of the state's Constitution.
Very good. Thank you for that. And I do have folks that signed up to testify today. Members, we're going to go ahead and go out of session and hear from them. I'm at the will of the committee. All right. Without objection, we're going to go out of session. And I have Jimmy Music. Jimmy, are you out there somewhere? I don't see you in here. And Rachel Russell, Steve Crump, Mike Donovan, Courtney Lynch, and Jolie Ford. If any. Some folks may be outside in the hall, so Mr. Crump, you're the only one in here right now. There's Ms. Russell and Mr. Music, sir. Thank you. Y'all can. So we've got Mr. Music, Ms. Russell, Mr. Crump, Mr. Donovan, which Mr. Crump may cover that. And I have Ms. Lynch. I don't see her here, but okay, we're good with there. And then Jolie Ford. Okay, all right, good deal. All right, we're out of session. And I appreciate y'all coming in here. Mr. Crump, we'll just start with you, just a couple of minutes each, if you don't mind. Just give us your position. We're on House Joint Resolution. We're on Representative Reed's House Joint Resolution 53.
Thank you very much, Mr. Chairman and committee. My name is Stephen Crump. I'm the Executive Director of the Tennessee District Attorneys General Conference. We are here in opposition to this resolution, and this, our issue with this piece of legislation is that we believe that by amending the Constitution in the way that is named here, it will prohibit potentially the General Assembly from not only regulating certain firearms, but also do away with many of the criminal offenses that are related to firearms as they currently sit on the statutes. And with that, it's a very simple objection. That's what it says. And we look to the last amendment of the Tennessee Constitution, which was in 1871. that addressed this, and they specifically added the provision that is looking to be removed to prohibit there being some form of confusion or ambiguity about whether or not the General Assembly had the opportunity and the ability, for example, to regulate felons having firearms. So with that, I will stand for questions.
All right, Ms. Russell, you're recognized.
Rachel Russell, I'm Deputy Counsel of Operations with the Tennessee Bureau of Investigation. The TBI is also opposed to this constitutional amendment, and for the exact same reasons that General Crump just explained to the committee. We have done some research and looked at some of the Tennessee Supreme Court cases that came out right after this amendment was passed that explain the reason for the amendment. And based on that, it is also our position that we are in fear of what the courts will now do when looking at the current statutes that are on the books as it relates to firearms, specifically looking at sensitive places, the regulation of sensitive places, and individuals that have been committed as mental defectives, our domestic violence language, things of that nature. That is what we are specifically concerned about.
And thank you for that. Mr. Music, you recognize, sir.
Thank you, Chairman and Committee. Jimmy Music, represent the Tennessee Sheriff's Association, Tennessee Association Chiefs of Police. Sorry, I'm allergies after all the rain. So nothing new to add. We looked at it and apologize for getting to this late. We actually had to get our sheriffs to vote over the weekend to tell us one way or the other on this one, because we were trying to figure out exactly what it would do. And so, you know, following the lead there from what they told you is just the unknown of what we have currently on the books and what will continue to stand or not. I mean, our fear is that the case law that has been created since 1870 when this was put in, we're gonna restart and relitigate those different aspects of the Tennessee law.
Very good. And thank you for that information. Members, any questions for our guests? And I do have a list, a personal list. I have Representative Johnson, ma'am. You recognize?
Yes, thank you, Mr. Chair. And thank you all for being here to answer questions. You know, my initial is that we know that guns are the #1 killer of children in the country. We know that in Tennessee, children die at a 50% higher rate than the national average. And so we know that gun violence is a problem in our communities. And so, you know, the idea of changing our Constitution that clearly states that we can regulate these, especially, you know, this might have been a later addition to the Constitution, but guns have certainly changed since, you know, early on. And, but I hadn't thought about a lot of the things that you brought up, domestic violence, mental health. So laws that are on the books, this is going to undo all those safeties and protections for those folks. Is that what you're telling us?
Mr. Crump?
That's fine. Thank you, Mr. Chairman. We are uncertain how the courts will rule. However, we know that the original Tennessee Constitution read similarly to the one to the amendment that is proposed. Mm-hmm. In the 1870s, and between 1796 and 1871, there were a significant number of regulations that the Tennessee General Assembly passed related to the possession, the carrying of firearms, the discharging of firearms. In 1871, the Constitution was changed to add specifically the language that this amendment seeks to remove. And if you look at the decisions that were promulgated by the courts around that time on both sides, it was felt that this was necessary in order to prevent there being any ambiguity. And so we are making no judgment as to the cause of firearm violence. We believe that the Second Amendment is an extremely strong part of our Constitution, and we believe that it must be revered and upheld. However, every right that we have is subject to some form of regulation in some form. And so we believe that this would create very significant difficulties on this body in trying to prevent violence in some forms, and also will reduce public safety.
Thank you. So what you all are saying is for well over 100 years, they have recognized that the legislature should be able to have some sort of protections in place for the community. And it's been well over 100 years, correct?
It has been since 1871 that this was changed. I don't know what they felt. I just know what they did.
Right. Thank you.
Very good. Next list, I have Representative Balso, sir.
Thank you, Mr. Chairman. My question also is for Mr. Crump. Thank you for being here. You agree, obviously, that if there's a conflict between the Tennessee Constitution and the U.S. Constitution, that under the Supremacy Clause, the U.S. Constitution controls, correct?
Thank you, Mr. Chairman. Yes, sir, of course.
And when we look at the language in this resolution, I mean, you will agree that it is substantively identical to the operative clause of the Second Amendment, correct?
You guys can have it. You can go ahead and respond to one another.
Yes, I do agree that it is at least in substance the same as the Second Amendment to the United States Constitution.
And we know that the Second Amendment was made applicable to the states via the 14th Amendment in Justice Alito's decision in McDonald versus City of Chicago in 2010, correct?
Yes, sir.
And when the Second Amendment, which is substantively identical to this resolution, became applicable to Tennessee, none of the laws that we had on the books were found by any court to be invalid. Isn't that true?
No, sir, not under the Second Amendment nor under the Tennessee Constitution. However, if this body says that, in fact, this body does not have the ability to regulate firearms, then in effect, while there might not be a Second Amendment problem with this, there would suddenly become a Tennessee constitutional problem. It's not a question of can the states do what they're currently doing. The question is, can they continue doing it? The Second Amendment to the United States Constitution would not speak to that. The Tennessee Constitution would be the prohibition in this case, not the Second Amendment.
You agree, though, that as we're sitting here today, the Second Amendment, which is identical to this language, governs the state of Tennessee?
Yes, sir. But again, that would not be the issue. The amendment, that would not be the issue. The question would be, can this body regulate it? And if this body says, no, you cannot regulate it, no matter what the United States Constitution says, you all can go farther in that regard. You can regulate less than the Second Amendment says. You can't regulate more. This amendment would allow you, would prohibit you from regulating the same way you do now, potentially.
But there's nothing in this resolution that says that the state of Tennessee cannot regulate firearms. Isn't that true?
That's correct, sir. But again, the entire purpose of adding the language that's being removed was to prohibit and prevent there being an ambiguity in the state constitution about this body's ability to do it. It was not about the Second Amendment. It was that this Constitution was ambiguous in the eyes of the judges and apparently in the General Assembly's eyes. And so they changed the Constitution to remove that ambiguity. By specifically taking away that change, you open the door for the courts to then say the legislature knows what they intended. And if they intend to remove a provision that allows the regulation in any way of firearms, they must mean that they do not want this body to ever be able to regulate that.
Respectfully, Mr. Crump, isn't it more likely that what our Supreme Court of Tennessee will decide is that by adopting the precise language of the Second Amendment, that the court will conclude that this body wanted to incorporate federal laws regarding the Second Amendment, including Heller, McDonald, Bruin, and other recent decisions from the U.S. Supreme Court, including the Rahimi decision?
I don't believe so. I'm not saying they will or won't. I don't think we know.
Okay, thank you very much.
Very good. Next on the list, I have Representative Hardaway, sir.
Thank you, Chairman. And good morning to you all. Simple questions. I'm not a lawyer, so I pride myself in asking questions like a layman. What will happen, this is for Mr. Music, what will happen in the field if the ability for the legislature is hampered by this amendment? what will happen and just in real life? What are the sheriff's deputies and other law enforcement, including our own state troopers, TBI, what are they going to face in the field possibly that they're not facing now?
Thank you, Representative Hardaway. So not sure how much would change if this, was adopted by the citizens in 2026, or I guess in the next gubernatorial election where it would be up. The question would be your enforcement mechanisms for law enforcement is how do you adjust your business to make sure that you don't run afoul of this? I think generally my reaction would be until a court opine one way or the other, they probably will to some extent continue to do what they have been doing. But we're not exactly sure because, just take on the layman side of this. The Constitution now says that you can regulate the wearing of arms with the intent dealing with safety. If you take that out, then what does that mean? And we don't know, but I guess we would find out as to where the courts come down. It's possible that they could say that yes, that it it overlaps with the Second Amendment exactly, but I just don't know how. And our concern is how do you remove something is so specific and say it means nothing, that it does nothing? That doesn't make a lot of sense to us.
All right, and I believe that you said, made reference to the fact that those who are incompetent and violent felons may have access to firearms.
Well, and that's our concern when we're looking at the fact that the language currently says that the legislature has the right to regulate with a view to prevent crime. Those are the types of statutes that have been passed under, it is our belief that that is the legislation that has been passed under that specific authority of the Constitution. And so if that language is removed from the Constitution, then that is our concern, that a court, that the way that our state currently, the way that the courts have ruled and the way that they have looked at statutes that we have had going all the way back to 1871, that the courts have looked at this language and have said this is what the legislature is allowed to do. They've looked at those statutes through that vein. So our concern is that it could put all of that case law in jeopardy if the concern is now raised. If this is to pass, that just as General Crump has indicated as well, if this is to pass, that now when a court goes and they look at the legislative authority, that they are going to say that there is a reason that that language was pulled out. And because that language is not there anymore, the legislature no longer has that authority. And that is some of the analysis that as we've kind of gone back in researching this, there's a Tennessee Supreme Court case from 1871, and that's the exact analysis that our Tennessee Supreme Court case went through, was they looked at a statute that had been passed that same year, and they said, they looked at it through the vein of that language that was passed in 1870. And they said, specifically, if we're looking at the meaning of the Constitution, of that language, what limitations does our Constitution impose on the power of the legislature to regulate this right? And they said, that's the question before us. And so our position is that the courts would take that exact same analysis after our Constitution is changed. And so that's our concern, is if they do that exact same analysis once the Constitution is changed, then will they change the prior decisions and say that our General Assembly no longer has that ability to regulate?
And the last question is for General Crump. What would this do to your members in terms of their ability to keep Tennesseans safe? Is it going to make it more difficult or less difficult for prosecutions of violent felons to keep those who are mentally incompetent from having weapons and walking around? What will this do to the way that you all enforce whatever laws that are current or those coming down that you anticipate coming because of this possibly passing?
Thank you, Representative. I think much like Jimmy Music said, it's at the beginning, I don't think there would be a lot of change. I think that the change would occur over time as as somebody potentially was indicted for a particular offense or charged with a particular offense. And those cases wound their way through the various appellate courts. And we also agree, and the analysis that Mrs. Russell actually spoke to, I think that's the guidepost for the current Supreme Court to look back at the last time that this happened. Looking at this language, we think that there is a significant chance that the court would say, this General Assembly put this language in because they thought they did not have this authority earlier. And now they are removing it. And because you all are deemed to understand, and by the courts deemed to understand, not just the language that you're putting in, but also the ramifications of the decision, then we believe the court, there's a very good chance the court would say that you have prohibited yourselves from passing laws. Therefore, the laws that are related to those are no longer enforceable. So I don't know, I can't tell you that there would be any change at the beginning, but certainly the litigation would be significant, we believe there's a significant chance that the law could change as it currently stands.
Thank you. In essence, you oppose the HJR?
Yes, sir.
All right. And
Yes.
you also, and you, ma'am?
Yes.
All right. Thank you, Mr. Chairman. Thank you all for being here.
Representative Towns.
Mr. Chairman, thank you, and thank you all for testifying as well. Around the country, are you familiar with any legislation that's similar to this, where it's modifying the Constitution of that particular area, that particular state, and what the results have been? Maybe a couple of years later, it may be something out there, it may not be something. Just curious.
Representative Towns, I am not familiar with that. I have not looked at that question. Frankly, because this was, our provision is so specific and the analysis to it was so specific as well, I really didn't feel the need to look outside, because the court's going to have to interpret what you did specifically, right, what this body did, and what the voters of Tennessee do in the subsequent gubernatorial election. And so I've not looked at it. My colleagues may have, but I have not.
Okay. Okay, thank you.
Representative Powell.
Thank you. So just to get clear, some clarity on this, the represent the district attorneys, you represent the TBI, you represent law enforcement and sheriffs. There is potential with this constitutional amendment that felons and those with mental health issues, currently we limit their ability to get firearms, could obtain those firearms lawfully, potentially, if this resolution passes. Is that correct?
Yes, Representative. And let me say this, it is the traditional policy of the Tennessee District Attorneys to remain deferred to the will of the legislature on gun-related matters. We believe that those are wholly in the province of the General Assembly. However, on occasion, we feel like that those become so significant that we have to be heard, and this is one of those circumstances.
All right, very good. Representative Doggett, or excuse me, Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. Thank you all for being with us. Prior to 1870, what was the reason for the change in 1870 to adopt the current language that we have now?
And Chairman Doggett, so I can't speak to the intent or the will outside of what I've read within case law, obviously. So, but looking at, so there's a specific Tennessee Supreme Court case, it's Andrews v. State, that is from 1871. And so there were a couple things that were changed in 1870. Specifically, they changed the language that previously, they changed the language at the front, which is not being altered by this resolution, that talks about, in 1870, they changed it to where it said that the citizens of this state have a right to keep and bear arms for their common defense. The other, so the language that was actually added, that was not modified but was added, is the language that says for their common defense, and then also that section, that last second or sentence, which is what this resolution would remove. So that specifically was the newly added language in 1870, and that newly added language is, but the legislature shall have power by law to regulate the wearing of arms with a view to prevent crime. And again, in that case in Andrews v. State, the Tennessee Supreme Court specifically said the Convention of 1870, knowing that there had been differences of opinion on this question, have conferred on the legislature in this added clause the right to regulate the wearing of arms with a view to prevent crime. So looking at that case, again, I'm having to interpret what the court meant there, but looking at that case, it appears clear to me that the purpose of that change in the Convention of 1870 was based on the fact that there were differences of opinion, and then the court actually discusses some cases that occurred prior to that, and clarifying that that's why that they did what they did.
Thank you. I know that there's been, there was a change in 1834, a pretty substantial change in regards to this, and which was different from 1796. But I personally do not believe that by removing this clause that we are going to limit any of the abilities in which the legislature has, and I echo some of the comments a colleague made earlier in regards to it closely, I believe it closely more mirrors what our U.S. Constitution says. And I think that really reading what we have now currently in our Constitution may have been in response to something in 1870 versus what it was when this state was founded in our first Constitution. So thank y'all. Thank you for being with us.
All right, members, that's all I have on the list for our guests. Any additional questions? All right, seeing none. Any objection going back into session? All right, back in session. Thank you all for being here. Now we're back on the resolution. Members, any questions for Representative Reedy? You have Chairman Todd, you're first on the list.
Thank you, Mr. Chairman. There's a lot to unpack here with the testimony we just heard, and even some of the questions. You know, guns being the #1 killer and gun violence. Once again, these phrases just keep coming up, and I don't think there's anybody in this room that's ever seen a gun or a hammer jump up and hit somebody or hurt somebody. But we constantly talk about inanimate objects like they're alive, so it's kind of ludicrous to even for our guests to refer to that. You know, some of the comments about the timing of this constitutional change in Tennessee is really interesting, and it's very significant. When was this? This is right after the Civil War. We had Jim Crow laws being passed. We had the KKK attacking people. All of these things were happening to the freed black slaves of this state in error. Yet the citizens of this state wanted more provisions that kept those freed black slaves from arming themselves and defending themselves. That's exactly what happened here. In referring to the court case that was mentioned, Andrew v. State of 1871, right after the constitutional amendment in question, Justice Scalia in Heller stated, in Andrew v. State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol publicly or privately without regard to time or place or circumstances violated the state constitution provision, which the court equated to the Second Amendment. Even in 1871, our Supreme Court, in the court case that was literally just talked about, equated our Constitution and our rights to the Second Amendment held in the U.S. Constitution. And that was so even though the statute did not restrict the carrying of long guns at that time. So I'm very honored to be able to vote on this today and once again right the wrongs that was done in 1870 with this constitutional amendment. I appreciate the sponsor bringing it. The assertions that our laws are going to be upended is absurd. As a matter of fact, the U.S. Constitution does not contain this language, yet there's a list of federal laws that we refer to regularly in this committee that restrict firearms, sales, purchases, wearing, the whole thing. So does anybody in this room think that we won't be able to prosecute murder if this constitutional amendment is changed? No, not at all. We will still be able to regulate. Does our code need rewriting? It absolutely does. It's confusing. The average citizen cannot read it today and understand who can carry, when they can carry, or where they can carry. It's extremely confusing. It needs to be rewritten. So, sponsor, I appreciate you bringing this bill. Thank you, Mr. Chairman.
All right, very good. Members, I have Representative Hardaway. You're next on the list for the sponsor.
Thank you, Mr. Chairman. My ancestors were mentioned. I appreciate that. And I wish we had the same energy for the rest of the civil rights laws which were put in place during Reconstruction and reverse and post-Reconstruction. We fought again during Jim Crow and reversed again under the current administration. But I'm going to state simply that I don't consider any of the testimony being ludicrous. I think that the fact is our DA conference and the rest of the law enforcement, including Sheriff's Association, law enforcement that I've heard from, say that this is a dangerous way to go. There may be another way to proceed. There may be different language which would accomplish what my venerable friend wants to do, the sponsor. But I don't believe that this is it. There's too many unanswered questions that I have. And I think the testimony that we heard when we were out of session, Mr. Chairman, suggests that there are going to be too many questions that will be posed both in the field and the courts, including the appeals courts, et cetera. So once again, I appreciate my ancestors being cited here. And true enough, we had a bunch of amendments that were made to the U.S. Constitution in an effort to protect the rights of those who were formerly enslaved. Unfortunately, like some of the other precedents, we've seen the courts roll them back. So with that being said, I'm going to release my time. Thank you, Mr. Chairman.
Representative Townsend.
Mr. Chairman, thank you. To my good friend, Representative Reedy, I want you to enumerate for me, what is it that with this you're trying to accomplish? Just spell it out in 1, 2, 3, 4. What are you trying to do? I want to get that in my head.
You're recognized.
Thank you, Mr. Chairman and committee, and I feel obligated at this time to give you historical documents because I've been thinking about this since 2018, working on information. Of course, you know, this body knows that I did not, you know, I came to Tennessee from Idaho, and I read the Constitution before being an elected official, and I had some concern. And so with that, it's keep in mind in 1870, the population of Knoxville was estimated at 4,000 people with 400 slaves. Here in Tennessee, Nashville, where we're at now, it was estimated was 28,000 citizens in Nashville. So why did we change the Constitution? And here's the historical information. The first Constitution of the state of Tennessee was adopted in 1796. The Constitution was drafted in Knoxville by a convention consisting of 55 delegates. Once it was completed, the delegates sent the Constitution to Washington City for review by Congress before it adjourned. President Washington signed the bill giving Tennessee immediate statehood on June 1, 1796. Most of the provisions regarding declaration of rights, taxes, legislative authority were drawn from the North Carolina and Pennsylvania Constitution. So it wasn't just a brainchild, we just come up with it on our own. Article 1, Section 26, that the free men of the state have a right to keep and bear arms for their common defense. Okay? So the Tennessee Constitution was modified in 1834 with greater unease over slavery and came new language limiting the right to white citizens only. However, it was declared unconstitutional. Now remember that the Civil War ended May 13, 1865. Written in the local Nashville Dispatch on December 2, 1865, the headline read, "Carry a deadly weapon. Every good citizen is now supposed to carry a deadly weapon, and it is their imperative duty to shoot accurately when attacked by midnight assassins or robbers. A reward should be given to the citizen who kills the first highway robber in or out of the city." And then there was the note, the Nashville Dispatch ran from 1862 to 1866. From there, then in 1870, after the Civil War, we have Article 1, Section 26, language of today, that the citizens of the state have a right to keep and bear arms for their common defense, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime. At the constitutional debate leading up to the 1870 language, it was explained by Delegate John A. Gardner that the purpose was to deal with the wave of post-war crime and banditry. Due to the lack of law enforcement across Tennessee, citizens could be called together for training and equipment inspections and could be required to provide themselves with the necessary equipment, whether that included firearms or not. This would produce direct results in terms of law enforcement on the streets. It was noted by Gardner that his amendment recommendation, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime, was merely clarifying an already existing power of the legislature. The recent SCOTUS decision in New York State Rifle and Pistol Club versus Bruin requires that scrutiny regarding Second and 14th Amendment issues be relegated to historical traditions, quoting from the decision. The constitutional right to keep, or the right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. McDonald, and it says McDonald's 561 U.S. at 870 plurality opinion. We know of no other constitutional right that is individual may exercise only after demonstrating to government officers some special need. This is not how the First Amendment works when it comes to unpopular speech or the free exercise of religion. It is not how the Sixth Amendment works when it comes to the defendant's right to confront the witness against him, and it is not how the Second Amendment works when it comes to public carry for self-defense. The correct period analog of the Second Amendment from our 1796 Constitution does not give the power to the General Assembly to deny a civil right, and as the Second Amendment was enumerated as a right of the people and incorporated against the state in 2010 by the SCOTUS McDonald versus the City of Chicago, the legislature has no power to constrain it. Sir, did any of that answer your question and the intent of what I'm trying to do?
Representative Towns, you're recognized.
Well, obviously there was a lot in there, as you stated, and so partially yes, but today, if this passes, it actually does just your top 2 or 3 things. What will it do? Your top 2 or 3 things if it passes.
So
in your opinion.
Thank you, Mr. Chairman. To me, because of the court rulings, the Supreme Court rulings, I believe our Constitution is suspect for lawsuits, number one. Now, already we know with enough votes that we could sell the lantern off the top of the Capitol. So there's, when we say that all the wheels will come off if this becomes a constitutional amendment change, we got to ask ourselves, why did we change it in the past as a legislative body? Why did we do that? Who were we trying to alienate? And what are we trying to do now?
Okay. All right, but Mr. Chairman, if you will, for you and people that are gun owners, gun carriers, this, that, and other, and the ones that have license, the ones that carry based upon our most recent law, it won't impact that at all, will it?
No, sir, it's not.
Okay.
I think it's consistent with our state laws.
Okay. That's what I thought. It will not impact it one way or the other. Okay, that's good for me. Thank you, sir.
Representative Johnson.
Thank you, Mr. Chairman. And it's, you know, at least a bit, I'm hearing some progress with some of my colleagues who voted against taking slavery out of our Constitution, but are for arming slaves now. So I guess my question is, you're in some of the things you mentioned from 1870 was that there was a lack of law enforcement. And so my question is, we have law enforcement now. Law enforcement has overwhelmingly told us that they don't support this legislation. So what do you have to say to that? And also, does this mean kids can be armed as well? So if we're not going to be able to regulate?
Representative Reedy, you recognize, sir.
Thank you, Mr. Chairman. Okay, so the intent of the law is going with, consistent with our Second Amendment rights. And then I'm trying to unpack
Sorry.
the rest of your question. Being suspect of
it was two parts. So the one part that's probably the easier ask is about children. It seems like this would prevent us from being able to put regulations when it comes to children having firearms.
And I don't believe that would do that at all. I mean, it's consistent with our constitutional carry, so you don't have to have a license to carry right now. And of course, we're already talking about, and hopefully the bill's passing through, stating that an 18-year-old and can own and wear a firearm, and that that gives me great pause that I served in the military, and I was trained on weaponry from a handgun all the way to an M60A3 battlefield tank. But when I come back to the United States, I could not drink a beer. I need to be 21 or own a firearm 21, and it was just crazy that the military provided me all of the training to do that, but then I become just a regular citizen, and I lose all of that until I turn of age of 21. So that's part of my challenge too.
Well, what about 12? If there's no constitutional reason that we can challenge or regulate for protection, then what's to prevent a 12-year-old from being able to open carry?
I believe that would have to be determined in the courts. It's no other state allows that, so I don't see it.
But they probably are not removing a provision that allows us to regulate that. We would be removing the provision that allows us to regulate that. And that is my concern, especially when all the law enforcement in the state says that they are against this piece of legislation. But thank you.
Thank you. Representative Bolso, you recognized.
Thank you, Mr. Chairman. I move previous question.
Very good. Previous question has been called. Any objection? There's objection. Members are going to be on the board. All those in favor of previous questions, vote aye. Those opposed, vote no. Does everyone remember voting? Anybody like to change the vote? All right. Madam Clerk, if you take the vote, please.
Mr. Chair, you have 15 ayes, 6 noes, and 0 present not voting.
Very good. Previous question prevails. Members, we're going to be voting to send House Bill HJR, Item 36, HJR 53 to Finance, Ways and Means. All those in favor, vote aye. Those opposed, vote no. All right, Madam Clerk, if you would please take the vote. Thank you.
Mr. Chair, you have 14 ayes, 7 noes, and 0 present not voting.
HJR 53 moves to Finance, Ways and Means.
Thank you, Chairman and Committee.
That brings us back to item 15. Members are going to hop back. That's House Bill 49. Vice Chair Davis. You got a motion and a second. There's no amendments. You're probably recognized.
Thank you, Mr. Speaker. Sorry, I lost my voice. This bill has 3 parts. It's brought to us by the District Attorney's Conference. And in these 3 parts that this bill ensures that legal counsel and advice can be provided by the Executive Director of the Tennessee District Attorneys General's Conference, and that it's privileged and confidential. The second portion, or the second purpose of this bill, is that it closes certain portions of the conference executive committee and finance and audit committee meetings to the public. And then also it states that a pro tem may be appointed in civil proceedings, not just criminal proceedings. Thank you, Mr. Speaker.
Thank you for that. Thank you for the explanation. Members, do you have any questions? Representative Johnson, you had your hand up. Do you have a question for Vice Chair Davis?
Yes, thank you. So it's my understanding that the comptroller said that the DA generals weren't following the current open meetings requirement. And so the result is that we're removing the open meetings requirement for them because they got dinged for not having open meetings?
So this legislation has to deal with those attorney-client privilege conversations. And that is what we're ensuring, that because the District Attorney General's Conference are the attorneys for the district attorneys. And so they need to be able to have attorney-client privileged conversations. If you have some more questions with regard to a report from the comptroller's office, you may want to speak with them directly.
Any additional questions, Representative Johnson? All right, thank you. Members, seeing none, we ready to vote? Any objection to the question? All right, members, we're voting to send House Bill 49 to calendar and rules. All those in favor vote aye. Opposed, vote no. Every member vote. Anybody want to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 49 is moving to calendar and rules. And we're going to move down, members, to item 38 without objection. Representative Shaw has been sitting there patiently. House Bill 1274. You got a motion in a second. I see House Amendment 7059, sir.
That's correct.
You've got a motion in a second on your amendment. Members, we're going to go ahead and adopt that amendment. Any objection to doing so? Seeing none. All those in favor of adopting House Amendment 7059 to House Bill 1274, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Mr. Chairman. What the amendment does, it sunsets it July 1st of 2029, providing there were no cases to be found. And what this bill does, it was brought to me by one of our constituents. This bill would simply call for the Tennessee Department of Investigation, a bureau, to provide a report to the Speaker of the Senate and the House on or before January 1 of each year, dealing with the instances, most recent instances, when it comes to people being charged with driving under the influence, and there's no alcohol or any kind of intoxicants found. And we're just trying to find out how many of those reports across the state of Tennessee, and it would sunset July 1 of 29 if there were no instances found. That's the crux of the bill.
Thank you, sir. Leader Lambert.
Move previous question.
Previous question has been called. Any objection to the question? Seeing none, members, looks like we're ready to vote to send House Bill 1274 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Is there a member voting? Anybody like to change the vote?
Thank you, sir.
Madam Clerk, if you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Congratulations. House Bill 1274 as amended is moving to calendar and rules.
Thank you.
Very good. Members, that brings us back to item we were on item 15. If we could, members, without objection, move to item 24 by Chair Lady Littleton. House Bill 1355. Got a motion and a second. See House Amendment 5251. Members?
Motion on the amendment.
Got a motion and a second. Do we want to go ahead and adopt that amendment? Any objection to adopting House Amendment 5251 to House Bill 1355? All right, seeing none, all in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Chair Lady, you recognize.
Thank you, Mr. Chairman. House Bill 1355, as amended, specifies that the payment of a financial support to or for the benefit of the child or the child's mother during a pregnancy or when the mother has had physical custody of the child does not include token financial support as it relates to the criteria of the punitive father. It authorizes a declaration as permitted under Rule 72 of the Tennessee Rules of Civil Procedure to be filed with an order of adoption by certain entities in lieu of an affidavit detailing fees charged for certain services.
Very good. Members, any questions for Chair Lady Littleton? Representative Johnson, you're recognized.
Yes, thank you, Mr. Chair. One issue that was brought to me I want to get some clarity on. There was the suggestion that perhaps if a father at the time was not aware that they had a child and learns that they would have no recourse after this bill is passed.
Jody?
Thank you, Mr. Chairman. It does say in Tennessee, a punitive father is a man that does not have an established legal relationship with a child but claims to be the father's biological father. Punitive fathers must have either paid financial support to the child or mother during pregnancy or while the mother had physical custody of the child. Okay, I guess that their question is if this father was not aware that they were the father and they find that out,
and they would not be able to do anything about that. They would have no recourse, because it's not because they knew and didn't help or anything like that. It's just that they never knew. And when they found out, it was too late for them to attempt to have access to the child. So maybe that's a question for legal, I don't know.
Yeah, members, you want to go to session here from legal? Yeah, let's do that. Any objection? Ms. Fogarty?
Michelle Fogarty, Office of Legal Services. The bill specifies that someone who is a putative father who pays just a token amount of financial support, well, they would not be considered a putative father. So it would apply to a person who is paying a small amount to the mother, not someone who is not aware of the birth mother.
Okay.
You have any additional questions for Ms. Fogarty?
I just want a little follow-up. So there's nothing in the bill that would prevent a father who has just learned of that he was the parent from taking action to pursue that?
Correct.
Thank you.
Leader Lambert, any questions for Ms. Fogarty?
Just a follow-up on that. I mean, in order to even fall under this statute, you have to establish parentage first. And so you can't fall under the putative father statute if you've not established that you're actually a father yet. So to the question, would it not be accurate to say that until you've actually attempted to legitimize the child and gone to court, because obviously we know who the mother is, but establishing who the father is has to be done through a legal process. And until you do that, you don't fall under any of these statutes, correct?
That's correct.
Okay, thank you.
Very good. All right, members, any more questions for Ms. Fogarty while we're out of session? Any objection going back into session? Seeing none. All right, back on the bill. Any questions for sponsor? Question's been called. Any objection to the question? Seeing none. Members like to ready to vote to send House Bill 1355 as amended to calendar and rules. All those in favor vote yes. Opposed vote no. Is there a member voted? Anybody like to change their vote? All right, Madam Clerk, take the vote, please.
Mr. Chair, you have 17 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 1355 is moved to, as amended, is moved to calendar and rules. Brings us to item 25, also by Chair Lady Littleton. You got a motion and a second. I see House Amendment 5490. Got a motion and a second. Members who want to go ahead and adopt that amendment? Any objection to adopting House Amendment 5490 to House Bill 1356? Seeing none. All those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. Ma'am, you're properly recognized.
Thank you, Mr. Chairman. This bill, as amended, enhances kinship placement options for allowing DCS to search closed adoption records solely to identify biological siblings or of children entering foster care. Why this matters, in some cases, a child entering foster care has biological siblings who were previously adopted, and under current law, DCS cannot assess those records to explore the potential sibling placement. So Family First approach, this legislation aligns with Tennessee's commitment to family unity and ensures the siblings who qualify as kin under existing law have opportunity to be placed together when possible.
Members, any questions for Chair Lady Littleton? Seeing none, question has been called. Any objection to the question? Seeing none. Members, looks like we're ready to vote to send House Bill 1356 as amended to calendar and rules. All those in favor say or vote aye. Opposed? Nope. Every member vote? Anybody like to change the vote? Right, Madam Clerk, you take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1356 as amended is moving to calendar and rules. Brings to item 26, House Bill 1357 by Chair Lady Littleton. You got a motion and a second, and I'm looking at House Amendment 6580.
Second.
Very good. You got a motion and a second. That's the correct amendment, I believe. Members, you want to go ahead and adopt that amendment? Any objection to adopting House Amendment 6580 to House Bill 1357? Seeing none, all those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. Chair Lady Littleton, you're properly recognized.
Thank you, Mr. Chairman. House Bill 1357, as amended, enacts the End Childhood Hunger Act, which creates a task force that is administratively attached to the Department of Human Services to recommend a strategic action plan to guide the administration and Tennessee General Assembly on how to end childhood hunger. Specifies that the task force will have their first meeting on July the 1st of 2025 and will meet electronically at least every 3 months, and requires that the task force submit a report of its findings and recommendations to the General Assembly by July the 1st, 2026, at which time the task force will cease to exist.
Very good. Thank you for that explanation. Members, any questions for Chair Lady Littleton? Seeing none. The question has been called. Any objection to the question? Seeing none. Looks ready to vote to send House Bill 1357 as amended, calendar and rules. All those in favor vote yes. Opposed vote no. Has everyone voted? Anybody like to change their vote? All right, Madam Clerk, if you would please take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1357 as amended is moving to calendar and rules. That brings us to item 27, House Bill 1360, members. Second. Also by Chair Lady Littleton. You got a motion and a second to have House Amendment 6094. Members? Second. You got a motion and a second. Members, we will go ahead and adopt that amendment. Any objection? Seeing none. All those in favor of adopting House Amendment 6094 to House Bill 1360 say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Mr. Chairman. As amended, this bill expands the definition of abuse to include when a person under 18 years of age witnesses either the abuse or domestic violence of another child in their immediate family or household. Requires that if the child has been removed from the custody of the parent or legal guardian due to finding of abuse and placed in foster care, unification with the parent may only occur if the parent takes parenting classes and domestic violence classes and the children get therapy. And then it requires that the DCS reports back every 6 months to the department. It reports back about how many children have been returned back to DCS custody once they were returned back to the home. But it does leave a pathway for them to get back home to the parents. Hopefully, the classes will help.
Sure. Members, any questions for Chair Lady Littleton? The question has been called. Any objection to the question? Seeing none. Members also are voting to send House Bill 1360 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Is there a member voting? Anybody like to change their vote? Madam Clerk, if you'd please take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Congratulations. House Bill 1360 as amended is moving to calendar and rules. Members, without objection, we're going to move on down to item 53, also by Chair Lady Littleton.
Thank you, Mr. Chairman. Could we roll the last few I have to the heel, please, of the calendar?
We can leave them right there, as a matter of fact, and we can go back to where we were without objection. Yes, sir. That'll move us to item, without objection. Members, we can move to item 40, House Bill 1299. That's by Leader Lamberth. And you have a motion and a second. We have House Amendment 5183. Got a motion and a second. Members, any objection to adopting House Amendment 5183 to House Bill 1299? All right, seeing none, all those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on House Bill 1299 as amended. You recognize, sir.
Thank you, Mr. Chairman. For those that were on the subcommittee, you heard significant testimony from a victim who had been taken advantage of by someone online who had created an AI deepfake image of her. And Ms. Bree was here. She testified, offered to testify again, and I told her that I was confident that this committee would support a bill of this nature to make sure that that type of horrendous behavior is illegal. That is what the bill does. I would ask for support of it in honor of Ms. Bree and all of those out there that have been taken advantage of by AI deepfakes.
Members, any questions for the sponsor? Seeing none. Question's been called. Any objection to the question? Seeing none. Members are voting to send House Bill 1299 as amended to Finance, Ways, and Means. All those in favor vote aye. Opposed vote no. Is there a member voting? Anybody like to change the vote? Madam Clerk, take the vote, please.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1299 as amended is moving to Finance, Ways, and Means, sir. That brings us to item 41, House Bill 1332, also by Leader Lamberth. You've got a motion and a second. Sir, I see House Amendment 4362, members. Got a motion and a second. Do we want to go ahead and adopt that amendment? Any objection to adopting House Amendment 4362 to House Bill 1332? Seeing none, all those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on House Bill 1332 as amended, and you're properly recognized, sir.
Thank you, Mr. Chairman. It does what it says there.
Very good. Members who have any questions for the sponsor? All right. Any objection to the question? Representative Johnson, you're recognized.
Okay, so it lowers the age for a carry permit to 18, is that correct?
Leader Lambert, you're recognized, sir.
Yes, that
For
is
carry.
correct. There's already a court order on that. We're under a court order to do that, and that's what the department's doing here, is complying with what the court ordered us to do.
Very good. Any additional questions for the sponsor? Really clear. Chairman Todd?
As the court ordered, does this also lower the age to 18 for constitutional carry without a permit?
Leader Lambert, you recognize?
It does not. This just deals with the permit. I had anticipated at some point, and do anticipate at some point down the road, that issue would be dealt with in a separate bill. I would certainly support that. I think the court order would as well.
Thank you.
Very good. Members, any additional questions? Seeing none. Any objection to the question? All right, members, are we ready to vote to send House Bill 1332 as amended to calendar and rules? All those in favor vote aye. Opposed, vote no. Does everyone vote? Anybody like to change the vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 14 ayes, 6 noes, and 0 present not voting.
Very good. House Bill 1332 as amended is moving to calendar and rules. Members, if we could move down to item, also by Leader Lambert, to item number 51.
Motion.
That's House Bill 1232. You got a motion and a second. Members, we also have House Amendment 4908. You got a motion and a second on that amendment. Members, we will go ahead and adopt that amendment. We want to adopt Amendment House 4908 to House Bill 1232. Any objection? Seeing none. All those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended, sir.
Mr. Chairman, if we could, there was one issue that dealt more with the fiscal note than anything else. The intention of the bill is that if possession of fentanyl would be an arrestable offense, and it would carry a 30-day mandatory minimum sentence, but you would still be eligible after that sentence to go into drug court. The original amendment that we just adopted indicated right off the bat you'd be eligible. It's really best practice to do that after the jail time, and normally that's a 1 to 2 year program. So if I would move that we take up, if the committee would, Amendment Code 5486. It was untimely filed, but just due to the nature of how the committee's meeting.
Members, any objection to take up House Amendment 5486, untimely? All right, seeing none. We're on.
Thank you, Mr. Chairman. And that amendment, if we adopt it, would simply just say that after the 30-day mandatory minimum, that they would be eligible for drug court.
Very good. Members, any objection to adopting House Amendment 5486 to House Bill 1232? Seeing none, we ready to vote? All those in favor say aye. Aye. Opposed say no. Ayes have it. Now we're back on the bill as amended. Thank
you, Mr. Chairman. Again, very straightforward. Fentanyl is killing thousands of our citizens, and it absolutely is an issue that we have to address. And one of the best ways that can happen is to stop the behavior. And so when someone comes into court, if they've been arrested on this, if they have 30-day mandatory minimum, then they can get them dried out, get them into treatment. And it's the same thing we did with meth a decade ago. And so that's what this does. It just mirrors that. Because we're just losing too many citizens. It also treats every single overdose as a crime scene, because many of those are going to be crime scenes. Because if some drug dealer sells fentanyl to someone and it kills them, they're on the hook for penalties that are the same as second-degree murder. So that's what the bill does, Mr. Chairman.
Thank you for the explanation. Members, any questions for the sponsor? Seeing none, we ready to vote? Representative Salinas, you're recognized.
So, for the people that are have fentanyl overdose, so you're saying those would be treated as a criminal scene, but would detox treatment be available for them in correctional facilities?
Leader.
Yes, that's a medical procedure, so that's always available. So if somebody needs detox, then that is something that is normally done within a medical facility. What we had fixed in the amendment was them to immediately be eligible for drug court. That would be after the 30 days.
Okay.
Very good. Members, any additional questions for a sponsor? All right. Seeing none, we ready to vote? Any objection to the question? All right. Members, we're voting to send House Bill 1232 as amended to Finance, Ways, and Means. All those in favor vote yes. Opposed vote no. Is everyone voting? Anybody like to change the vote? Madam Clerk, if you would. Take a vote.
Mr. Chair, you have 19 ayes, 1 no, and 0 present not voting.
Very good. House Bill 1232 as amended is moving to Finance, Ways and Means. And that brings us down to item 52. Leader, are you carrying that bill, 1343? Is that yours? Is that
Yes,
Cochran?
sir.
Okay.
Yes, sir, yes, Mr. Chairman.
Very good. So how are you, House Bill 1343, members? All right, we got a motion and a second. There's no amendments here. You're probably recognized.
Mr. Chairman, this comes from the Treasurer's Office, and it just makes them more able to be able to identify if someone has an ignition lock device and whether or not they are truly indigent. This is done in court right now, and the Treasurer's Office has monitored that fund for years. It is always upside down, and quite frankly, there are too many folks that are taking advantage of the indigency aspect of that are not truly eligible for it. So this allows the Treasurer's Office to be able to cross-check that.
Very good. Members, do we have any questions for the sponsor? Seeing none. Any objection to the question? Are we ready to vote? Looks like we are. All right, members, we're voting to send House Bill 1343 to calendar and rules. All those in favor vote yes. Opposed, vote no. Has everybody voted? Every member voted? Anybody like to change the vote? All right, Madam Clerk, if you take the vote, please.
You have 17 ayes, 0 noes, and 2 present not voting.
Very good. House Bill 1343 is moving to calendar and rules. Members, we could move to item 60. Chairman Russell. Motion. And it's House Bill 1027. You got a motion and a second. And also you have House Amendment 5472, sir. Motion. You got a motion and a second. Members, we're going to go ahead and adopt that amendment. House Amendment 5472 to House Bill 1027. All those in favor say aye. Aye. Opposed say no. Ayes have it. Chairman Russell, you recognize.
Thank you, Mr. Chairman. Committee, House Bill 1027 as amended creates the Tennessee Victims Act to seek a grant program for law enforcement agencies to improve their clearance rates and District Attorney's Office to improve their case closure rates by providing swifter justice to criminals, more expedient relief for victims, and a better public service outcomes for Tennesseans.
Very good. Members, do we have any questions for the sponsor? Seeing none, are we ready to vote? Looks like we're not. Representative Johnson, you recognized.
Yeah, what you said, swifter justice. What does this bill do to make that happen?
Representative Russell, you recognize, sir.
Thank you, Mr. Chairman. What this does is create a grant program, and it could include hiring more investigators, purchasing technology to improve laboratory test results and turnaround times, and support service for victims.
Okay. Thank you. Answer your question. Very good. Members, any additional questions for the sponsors? Seeing none, we ready to vote? Any objections to the question? All right, members, looks like we're voting to send House Bill 1027 as amended to Finance, Ways and Means. All those in favor vote yes. Opposed vote no. Is there a member voting? Anybody like to change the vote? All right. Madam Clerk, you take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 1027 as amended is moving to Finance, Ways and Means. All right, members and folks, that's taking us to the end of today's time. We have another couple minutes, but without objection, we're going to adjourn and roll all of today's calendars. All remaining bills will be rolled till tomorrow. Same calendar. Thank you.